and folks for co-counsel and myself at the same time, like, shocker. That you. I didn't even think about it, it just came out.
Oh, that's
Shocker. Meanwhile, I was finding like when I took the baby bar, there was a woman next to me at the end, and she was taking her fourth or fifth time at the end. And there were two questions, we got two criminal law on mine. And there was one in criminal law really read like a torts question. And you guys have probably done it, it's like the horse is racing out across the street. It kind of reads like a tort, but they call the question is what crime? So at the end, she turned to me, she goes, those were two torts, right? And I said, absolutely, I'm sure that, yes, because I mean, I knew it was, like, for a second, I thought, did I get it wrong today?
Oh, you had that, and
What
then
am I doing?
that kind of
I
attack for,
want to be nice, and I'm not gonna help her, need to go, are you crazy? I was kidding.
so we had a kind of attack for like 30 seconds.
Just for a second, it was the opposite of this, experiment people, I was trying to make her feel better.
See, that's how I would do it from school.
I just smiled and nodded and then something happened, it was really fine.
She's probably as, full of herself.
Yeah, probably. Actually, no way. You kidding me?
What's up, Petey? What's up? Nancy.
Hey!
Hi. Good, how are you?
Hey! Oh my God! It looks like some more from me.
I know, it's so weird.
Ooh, I like your nails.
Oh, thanks.
Very Christmassy.
Yeah.
Just throw me the dry out here.
Nice weather.
It's really throw me the dry out here in the color.
Hello.
What date was that? That pan on that pen? Pan with the. Here's the judge. and the-
Everyone was warm.
Sex torts guy and Rod Soda.
It's my turn. 26.
Yeah, I love it.
Yeah,
I
27.
thought it was gonna be mine, but
Who's that?
I guess not.
Or ask, look for Steve Miller's email. Remember he
Oh, yeah.
Yeah.
Ooh. Daniel, are you on up to reach that?
I'm not gonna be able to.
Yeah.
What'd you do?
It was October 6th.
Yeah. You just left it open and just say.
Yeah, but it's not. It's your fault. Did you sign it or is that not? Usually ours. Wow.
There you go.
No, that's good.
finger. It's like working with balloons. Alright, teamwork.
No business.
No? I totally would have blamed it on somebody else. They'll just finish doing one of them like, I don't know. People just aren't paying attention, and what's happening.
He consented to the risk, I saw it.
I did.
Assumption of the risk. Alright. So tonight's the last night of new material, right? You were almost halfway done with real property. You're supposed to go, oh, but we love it. You wear the hat for me?
No, it's me.
Oh, okay.
You should say yes.
She said yes.
We're not waiting for me.
We're not training any lawyers for it.
Right?
No, I don't.
Sometimes you pander to the judge or professor, right?
I'll take my time.
There you go. Like today, when an opposing party said, well, she's not going to be able to love our child the same because she's having another child and she won't have as much time. And that was in the moving paper, so I managed to point that out. And I said, you know, not only was it offensive, but it's outright untrue, knowing that the commissioner has 3 children of her own. And that's like suggesting that she doesn't love her first child as much because she has 2 others. So she said, I did read that, Ms. Boucher. I took it with a grain of salt. Fair enough, Your Honor. So sometimes you have to pick out the right things to address. All right, so tonight's gonna seem a little confused and like a lot, but it's actually not. Okay, so in fact, when we talk about covenants and equitable servitudes, they really are quite similar, and a lot of the discussion is going to overlap with other elements, okay? So I don't want you to freak out. It's really not going to be that difficult. It's a bit confused in certain areas, but it just needs to absorb, so don't worry. Would you like me to do an overview first?
Okay.
So, when we talk about covenants, what is a covenant? It's a fancy word for something. It's an agreement, right? It's an agreement to do something or not to do something, right? So, a covenant is a promise to do or not do something related to what? What do we talk about here? Land, right? It's a promise to do something or not do something related to land. That, in a nutshell, is what a covenant is. It's unlike an easement because it's not a grant of a property interest, but rather a contractual limitation or promise regarding the land. That's how you distinguish it from an easement. So, can a covenant be negative as well? Like easements, we have affirmative and negative easements. Can a covenant be negative?
Yes.
See, court reporters would not like that.
Yes.
Yes. All right. I tell my children whenever they say yeah or uh-huh or they go like this, I say yes. You go yes. Why? Because court reporters don't like that, right? Okay. So we're getting ready for the courtroom. By the way, rule of thumb: when you go and appear in court, do not chew gum. Do not chew gum.
Yeah, don't do that.
Wow.
When you start talking and you were chewing gum and you think you're being very discreet about it, just know the court reporter's entire job is to take every word that you are saying, so they are paying very close attention. They will notice that, and they don't like it. So covenants can be negative. What are those called? Restrictive covenants. The restrictive covenant is a promise to refrain from doing something related to the land. Makes sense, right? Covenants can also be affirmative. I'm sure everybody's on board with this, right? A covenant that is affirmative is a promise to do something related to the land. Here is something that stumps people all the time, but if you learn it ahead of time, It will make your life so much easier when dealing with covenants and equitable servitudes. How do we distinguish a covenant from an equitable servitude? Because they look virtually identical. They're the fraternal twins of property. How do we distinguish them? How do we know which one we're going to approach? Anybody want to take a stab at it? Afterwards, you're going to go, oh, that makes sense, and now my life's so much easier. You look at the remedy that they are seeking. Okay? If they are looking for money damages, it's a covenant. If they are looking for injunctive relief, you're going to do an equitable servitude approach. Now here's the real question. What if you get an exam and the call of the question does not identify what remedy is being sought? Is there a fallback? Is there a default? Do you default to one or the other?
What covenant?
Is that an answer? Is that a question?
An answer.
So you default to covenant?
Yes.
Anybody disagree? Anybody want to disagree for fun? Everybody really tired because it's raining and we're not used to it? Yes. Try to stay awake for us. So. Okay. I might forget about it by next semester, so I gotta use it up. Okay. The answer is, you're not gonna like this. You have to approach both.
Oh.
Why? Because we don't know what they're seeking. Okay? So, in evaluating a covenant or equitable servitude, you determine if it's a covenant or equitable servitude based on the remedy that the plaintiff seeks. Again, money damages is for covenants. Injunctive relief is going to be equitable servitude. Now, this probably makes a little bit more sense when you get into remedies class, but let's go back to our contracts and torts because, heck, they always seem to come back, right? When we're talking about remedies for contracts and torts, when you get into your remedies class, you're going to go through this approach. We call it the doorway to equity sometimes. You have restitutionary remedies, right? Those are for money. Then we have equitable remedies. Those are for other types of things, right? For specific performance, injunctive relief, things like that. So you kind of have to get out of your own head here sometimes and just think back. Well, what did we do before, right? When we talk about remedies, if it's something where you're seeking some equitable remedy, wouldn't it naturally then go to an equitable servitude you should approach, right? So we just got to keep it simple for ourselves, okay? Now, we're talking about land here. So, in talking about easements, we started getting into these discussions about benefits and burdens, right? We talked about the dominant and the servient tenement. And we said the dominant tenement does what?
They benefit.
They benefit, right? The servient tenement, obviously, then is burden, right? I just have a little pocket there, sorry, I'm just not being weird here. Okay. So I almost choked myself out with my own necklace when I was working out earlier. The instructor had to come and help me because I was stuck to the Pilates reformer because it had caught behind me and my neck was choking. And I was like, I need this. She's like, you need to raise your arch or your bridge a little higher. I was like, I'm going to stop breathing. I need your help. So, okay, burden and benefit. Now this is where it gets interesting, guys, okay? When will the covenant run with the land? That's the question you're asking yourself here when we're discussing covenants. So when will the covenant run with the land? You have to ask yourself two questions, okay? Does the burden of A's promise to be run from A to A1. Does everybody understand what I mean when I say that? Okay. A and B have an agreement, right? The question is, if A sells or somebody else takes over and it goes down to A1, does the burden of A's promise, the first holder, right? Does their promise burden A1? Does it continue? That's what we mean by run. Does it continue, okay? Does the burden of A's promise to be run from A to A1? How do we determine that? Well, let me also start with this. When looking to see if the covenant will run with the land, why do we do burden first? Does anybody know, based on your reading and rules of burden and benefit? Anybody have a guess? No, it's still pretty confused? I get it. Okay, here's the trick. Because every element contained under burden, or I'm sorry, every element contained under benefit is part of the burden discussion. So why would you try and do a discussion and then expand? You probably want to do the full discussion and then narrow, right? And it also really helps for purposes of managing your time. Why? Because some of those discussions are going to be very similar. So if you have a good burden discussion, then you're probably going to be able to reuse a portion of that or manipulate that in some way slightly to make your benefit argument. Here's an even better thing. Once you get into equitable servitudes, a lot of the elements are same there too. That's why I was saying, don't find this to be so daunting, because you're going to find that it's actually a very similar discussion throughout, and the elements are going to be very similar. So you can actually tighten up those discussions pretty well. And once you finish burden, you've virtually done a great deal of your discussion for the subsequent areas as well. Okay? So let's walk through what that looks like.
I have a question real quick first.
Yes.
So when you say you're being burdened by it, does that mean the covenant's being enforced against you?
Well, it means that yeah, effectively, your
Yeah,
land is the
like-
one being burdened. You have to do or not do something on that land.
Okay.
Okay, does that make sense?
Yeah.
So let me give you this description. We live in a gated community, right? So there's a plat, there's a common scheme, which is one of the things we're going to discuss as well. If everybody in this group, and I think this is one of our cases too, so let's say all these people live in the same area, okay? And when they purchased, they were all in agreement to have certain things that they have to do to their land and not do to their land, right? Okay, so what you were saying is when you're burdened, it means you have to do something or not do something as part of some agreement, right? Because it's a promise, it's the contract, effectively, right? So that's why we get into burden, because you have an obligation to do something or not do something. The other people are benefited by you not doing that. Does that make sense? It's not like an easement where you get to go on their property to do something, but for example, with real property, is it going to keep up perhaps the value of the community if you commit to this covenant and you, for example, are making sure that you have the proper greenery in the front of your home and that it's painted a certain shade, that you don't end up with the hot pink house in the neighborhood that's going to decrease the value of the neighbor's property? Does that make sense? Okay. It's kind of weird when you think about all these rules and then you start putting them into actual, living circumstances, and everybody's driven by the purple house somewhere, right? You know what I mean? Or the house that has crummy lawn or cars parked in front of their house or whatever the case may be, okay?
I think the 3-story house in a 2-story district.
Mm-hmm.
Right.
Yeah, I had a case with that a long time ago, one of my earlier cases.
So the elements for a burden to run are going to be what we call, hold on. We're gonna say within. Okay? It requires a writing, intent, because everything always requires intent, doesn't it seem? Touch and concern. The land, not the parties. Horizontal. This is how I learned horizontal versus vertical. And vertical privity. And notice. Okay? So, that looks like I have weird letters there, but that's just because my cuff is hitting the screen. Okay, so let's start with writing. All right? This is an easy one. The original promise between A and B has to be reduced to a writing. Do you need a minute?
You're just fucking up.
No?
Sorry.
Okay.
Sorry for the language.
Thank you.
No, I'm good.
All right, good. I just saw the heavy sigh and I was like, ooh, something's not working over there. All right.
Which never happens with Max, actually, but
Apparently it does.
It's Christmas time. It's the virus.
Oh no.
That is precise. You're in the wrong place.
All right, so writing. This is the easy one, right? Writing. There must be, the promise that is between A and B must be reduced to a writing. Okay? So burden is all about A to A1. Okay? All right, the next one. The original parties, meaning A and B. It's not really all about A to A1, it's about A to B too. All right, excuse me, A to B as well. I don't want to get confused here with the numbers, right? All right, the original parties intended the covenant would run, and courts are very generous in finding this element. So they're going to go and look, did they intend for this to run with the land? So that discussion is going to be all about the words that were said, the language that was used, in the writing, in negotiating the writing. That's going to be very factually driven.
This is only on the original promise.
The original promise between A and B. Did A and B intend for the burden to run? Or was it just between the two of them? And then it would extinguish if A sold or it went to a new owner. The third element is going to be touch and concern of the land. The promise must affect the party's legal relations as landowner and not simply as members of the community at large. So, let me just point this out. Covenants to pay money to be used in connection with the land, such as homeowners association dues, or, and covenants not to compete do not touch and concern the land. Okay? So this has to be something with touch and concern of the land. This is something that would affect the land. This land, not just them as landowners of the community, of the community at large, but of this particular circumstance. Then we've got kind of a two-parter here. Horizontal and vertical privity. If anybody ever has difficulty, I think, we're in, doctorate level program, so I presume everybody understands this at this point, but this is how I learned it when I was younger. Every once in a while we get confused. Kind of like when you try and figure out if J comes before K in the alphabet and then you go, A, B, C, D, right? Who hasn't done that, right? All right, so everybody's done that. Horizontal is across, vertical, up and down, okay? So now we're talking about privity. Now we're back into a contracts discussion, right? So horizontal privity is the nexus between the original parties, A to B. Requires that they be in succession of estate, meaning that they were in a grantor-grantee or a landlord-tenant or a mortgagor-mortgagee relationship. That make sense? I saw two heads move and they were with hesitation. Okay, grantor-grantee, right? Some conveyance occurred, landlord-tenant, or mortgagor-mortgagee type of relationship, okay? They have an agreement. Vertical privity refers to the nexus between A and A1. It simply requires some non-hostile nexus, such as a contract, devise, or descent. Meaning, you have either sold to them, so it cannot be an adverse possession. You got that? Non-hostile. Cannot be an adverse possession. Why? Because that's going to bump into the next one about notice, right? Okay, so non-hostile nexus, such as a contract, devise, or descent, meaning you either conveyed it, you willed it, or you died and it went to your heir. Got it?
Contract, succession, what was the other one?
Contract, devise, or descent.
Oh, I'm sorry.
The only time vertical privity is absent is if A1 acquired his or her interest through adverse possession. Okay? Because you either conveyed it to somebody in some way, sold it to them, they inherited it, either through intestate succession or by will. And then notice, right? I don't know that I really need to get into a full-blown notice discussion with you, but that's where the end comes in. How many types of notice? 3. What are they?
Actual, record, and
Inquiry.
Right. Error, right? He got real confident and threw those 3 up, right? And then I was like, and what are they? And it was like, all right. Give me a second. Give me a second.
Now you're asking too much of me.
I promise you, by the end of this year, you guys will know all 3 areas of notice. And by year, I mean like the whole school year. But even by the end of this semester, you will be on top of it, right? And you're going to have my annoying voice in your head all through the review. You're supposed to stop nodding your head yes when I say that. Through review, because I'm just going to keep repeating everything. Because at a certain point, it's just going to sink in and you're going to be like, okay, notice there's 3 types. Error, okay, actual, inquiry, record. Inquiry and record are both constructive notice. Okay, how do we go now? And then you bump through the ones that are present, right? So this is a discussion, and how you approach this is, what is the type of remedy that is being sought? If it is seeking money, if the person is seeking money damages, you're going to do a covenant approach. Within that covenant approach, you're going to ask, will the covenant run with the land? What does that mean? Does everybody understand what that means? What does it mean? What does it mean?
It's like restrictions or whatever's attached to land. Goes down the line of ownership.
Precisely. So when is it capable of binding successors? Right? Future interest holders, effectively, or property holders. So that's precisely right. So now we get to the next question. Does the burden of A's promise run from A to A1, right? So does the burden run with the land is the question you're going to ask yourself. Well, In order for the burden to run with the land, certain elements must be met. You'll notice this sounds an awful lot like a rule, right? Those elements include writing, intent, touch and concern of the land, horizontal and vertical privity, and notice. This is going to look an awful lot like a negligence approach because of the mini IRAC, right? So you're going to go in and you're going to say writing. Under writing, you're going to put a line and you're going to say, original promise between A and B must have been in writing. Then you're going to go to intent. The original parties intended the covenant would run with the land. Then to touch and concern, the promise must affect the parties' legal relations as landowners and not simply as members of the community at large. Horizontal and vertical privity, then bump out horizontal privity. The nexus between the original parties require that they be in succession of estate. Vertical privity refers to the nexus between A and A1. It simply requires some non-hostile nexus. And then we have notice. Right? Because if the parties are on notice, doesn't it make sense that they would have it be bound? If they knew about it, what could they have done to keep themselves from being bound to it? Don't buy the land. Don't take the land, right? So if they have notice of this, presumably, if it meets the other elements, they're going to have to do it. So that's burden, okay? Everybody good with burden? As good as you can be over a quick discussion until we start applying cases to it? Yes, no?
Yes.
All right. Don't tell my kids, but sometimes the eyes in the back of my head stop working and I can't see your head nods. All right. I just tell them I have cameras everywhere. We have a monitor in the room. I'm like, I saw that, but I'll speak through the speaker in the room. I mean, I want my kids to know that I love them unconditionally, but I want them a tiny bit scared of me, right? Just a little bit. There you go. All right, so now the question we ask is, does the benefit of A's promise to B run from B to B1, right? Because B is the person being benefited by this. And in order to show that, we're going to use with V, okay? What do you think W stands for? Writing. How about I? Intent. What do you think T stands for? Touch and concern. What do you think V stands for? Vertical privity. All right, so slightly different, but very similar, right? Writing, the original promise between A and B was in writing. Interesting, sounds familiar, doesn't it? Now you see why we do this in this order? What do you think you're gonna do with that if you're using a computer? Copy and paste. What do you think you're gonna do with that if you're handwriting an exam? Rewrite the same thing, don't reinvent the wheel, okay? Now we get to intent. Original parties, A and B, intended that the benefit would run with the land. Now you flip the burden to the benefit, you talk about the same discussions, the same language, the same writing that was used. So it's gonna be very similar, isn't it? You're probably going to be able to slightly modify that section and make it the same make it the discussion for benefit. Be very careful though when you're cutting and pasting that you're making the modifications that are necessary, okay? Touch and concern. The promises affect the parties as landowners. Probably going to be a very similar, if not the same discussion, correct? See how this is starting to become less cumbersome? Okay. And the last one is going to be vertical privity, a non-hostile nexus. Now make sure you're clear on this, between B and B1. Now, it's probably going to be of a very similar variety, right? They either devised it, it went by descent, or it went by some kind of contract or conveyance of some sort. So, in fact, realistically, once you get through your burden discussion, the benefit portion is going to run very quickly, okay? Now, do you think that if you meet all the elements on your burden, 9 times out of 10, benefit is also going to be met? Probably, if they're darn near the same elements, right? So, bear that in mind as well. So now we go back and we ask ourselves again, when will the covenant run with the land? That's if both the burden and the benefit run with the land, right? And if you find that the burden runs and the benefit runs, then the covenant runs with the land, and the parties are bound, right? The successors in interest are bound. The reason I say that, and I don't want to just skip over that, is because you have to conclude these discussions. A lot of times we get to the end of the elements and then we just say like, okay, figure it out. We told you each one of them was met. No. I want the pretty bow, right? It's like ordering something on Amazon, but then they have that little box where it says, is this a gift? And you go, that's for me, but okay, I want a bow. Right? So you pay the $2, or sometimes it's free depending on what the organization is that you're purchasing from. Click the box, right? Click the box, give me the conclusion, make sure it's wrapped with a pretty bow. Assume that Professor Drucker and I just cannot keep track of that many elements at once, and by the end of it, we need you to tell us. Was the burden shown? Was the benefit shown? Give me the mini conclusion for each one of those. Then at the end of that, tell me if both the burden and benefit were shown to be met, all of the elements were met, then the covenant runs with the land, right? Wrap it up. It's an easy thing to do at the end. It's a little daunting sometimes when you're typing very, very quickly or writing very, very quickly, but it just finishes out the discussion, okay? All right, so that is covenants. Now, very similarly situated, we have equitable servitudes. Okay? Equitable servitudes are a promise that equity will enforce against successors. It's accompanied by injunctive relief. Is that dripping? Oh dear.
Neat. Here, okay, we gotta put that first. Then I'll get somebody. Here you get my design.
I can hear it now. That's upsetting. It's very upsetting to me. Okay, so equitable servitudes. Equitable servitude is a promise that equity will enforce against successors. It's accompanied by injunctive relief. To create an equitable servitude that will bind successors, you must meet the following elements. So what did we just say there again? To create an equitable servitude that will bind successors the following elements must be met. Okay? This is the one where you ask yourself, oops, I missed something. Can I get a witness? Okay. Now, why do you think E and S are together? What do you think that stands for? Equitable servitude, right?
I didn't
Okay.
say it, I just want to sound stupid.
No, never be afraid of it sounding stupid. I do it all the time. All right. Actually, it's precisely why I didn't answer a lot of questions growing up, because I never wanted to be wrong. And I find that one of my children is like that. One will just leap in and be like, I'm just gonna give an answer because you never know. And more often than not, he's correct. And the other one kind of wants to sit back and make sure that he has the right answer. You'll probably just have to leave that open because it's gonna pull that thing down. Okay, so we're back again. What do you think W stands for? Writing, right? That's writing. Generally, but not always, the original promise was in writing. So, again, we're going back to the inception, right? We're going back to the beginning. Then we're going to talk about the intent, okay? Again, you're noticing this is very similar, right? So, why is this helpful? Because when I inevitably give you a question where we don't tell you what the remedy is that they are seeking, you're going to be able to burn through covenant and equitable servitude if necessary, right? What are you going to start with? Covenant or equitable servitude?
Covenant.
Covenant. What part of covenant are you going to start with?
Burden.
Burden, right? Because it's the more burdensome of the two, right? Okay. Right. All right. Thank you. Love that. Okay. So the intent, the original parties, again, we're back to A and B, intended that the benefit would, I'm sorry, the parties intended that the promise would bind successors. So at this point now, what we're saying is the future parties are bound by this equitable servitude.
Slowing down.
That tile needs to be moved because it's already starting to soak in.
Yeah.
Mm-hmm.
Get a bucket.
That's like,
That's not the concern. My concern is the tile that's up there.
It's probably super heavy.
I don't know.
Okay.
My limited knowledge of plumbing, but I want to check that.
Just leave that open, please. Okay. So, touch and concern. The promise affects the parties as landowners. Again, we're starting to sound familiar, right? What do you think that stands for? Anybody? Notice, right? Notice, successors of the burdened land had notice of the promise. Okay? So they had notice of the promise. And at the end, just for good measure, because it makes for a better approach, writing, intent, touch and concern, notice, and ES for equitable servitude. So, witness, right? So we've got within, wit V, witness. All right? Privity is not required to bind successors. The notice element is now I want to talk about, anybody have any more questions about this right now? Yes.
You said that writing generally, but not always, the original promise was in writing?
Correct.
So
Generally, but not always, the original promise was in writing. I would say I don't know too many circumstances when you would be able to deviate from it being in writing.
Very rare.
Okay.
So
Very
chances are you're not going to get something that wasn't in writing that's still going to bind successors.
And why is that? Why is it very rare when you don't have to have a writing? Because
Statute of frauds.
it's a statute of frauds.
Okay.
Absolutely, until we go back to contract law again.
Any other questions? That was a good one. Thank you. All right. So now this is another category of equitable servitudes. This is going to be one that all of you have more knowledge about than you know. because we live in the land of common schemes. Now, common schemes do not refer to any of my clients that are co-defendants. They do not refer to my twins who come up with crazy schemes together in common and then try and run those schemes on everybody they meet. This is talking about subdivisions, okay? Gated communities, places that are HOA driven, okay? Someplace where you're going to get a plat map when you move in. Anybody ever seen one of those? Okay, so you get your map, right? And you've got the different streets for the community. Maybe there's a cul-de-sac over here, right over here. And then it shows all the little houses on each street, all little houses over here. That's a terrible plat map. But it's a map that shows the whole community, but it's literally little squares and all the roads, okay? And then it's got numbers over everything. So at the end, you're gonna say, oh, okay, there's 50 homes in that subdivision and they're all mapped out, right? Okay, anybody ever go to a gated community for like a party or something like that and they give you the little map and it shows you? That's a plat map too, okay? So this gets into the discussion of, well, there's several names for it, so don't be confused, but it's an implied equitable servitude. It's also called a common scheme. It's also called a negative reciprocal servitude, negative equitable reciprocal servitude, a number of different names for it, but it's all going to come down to the same thing. It's a common scheme doctrine approach, okay? There are two elements only. The first of which, when the sale began, the subdivider, or A, had a general scheme of residential development that included the defendant's lot. Okay? All we know is that if the subdivider owned this and they made all of this into a subdivision, the defendant's piece of land had to be within this subdivision. That's the first element. Okay? So we have to know that if this is the defendant's land, then it was contained within the original subdivision. Okay? The second element is that this person, the defendant lot holder, had notice of the promise contained in the prior deeds. Okay? Now, what's the common excuse you hear from people? Oh, I don't know, I'm like the third owner of the house, they didn't give me the CC&Rs. Those were given to the original homeowner, and we never got them.
The legal phrase for that, it's called, that's your problem.
Falls under the category of not mine, not my problem, right? So, again, there's two elements. One, that when the sale began, the subdivider had a general scheme of residential development. Again, we say residential development, okay? Of residential development, which included the defendant's lot. Two, the defendant lot holder, so this person here, had notice of the promise contained in the prior deeds. How can you get around it being in a prior deed? Well, because somebody just forgot to put it in there, right? Happens all the time. So then if you go back to look at the prior deed and it's not there, are you supposed to know? What's the answer to that? Oh, come on, you guys are in second year. It depends, right? You're not gonna probably have record notice because it wasn't contained in the record, right? Are you gonna have inquiry notice? Maybe, depends on what the community looks like and depends on what the promise is, right? Are you gonna have actual notice? Could you have actual notice even if it's not in the record? Yeah, because somebody told you, or you saw it, or you stumbled upon it, right? So you can never just say yes or no until you address all the areas of notice, right? Actual notice versus constructive notice are two different things, and then we have two different types of constructive notice. So just because it misses the record somehow doesn't mean that you can't walk up and down your neighborhood and notice that people don't have purple houses. Or notice that people don't have RV parking. Or notice that people don't have an extended driveway that goes clear across the entire front of their house so that you're living in a concrete lot. Right? Or notice that people don't have 3-story houses in a single-story neighborhood. Or notice that people don't have Spanish tile roofs in an area that doesn't have Spanish tile roofs. Right?
That's pretty common too.
It is.
Our roofs are very common. Be surprised.
Go next time you go into a gated community, look at all the roofs. They're all gonna have the same tiles or the same material for the most part. I know it's weird, but then you're gonna start driving around, you're gonna see all these things. Oh, I notice everybody has 2 trees in their lot. Yep, because it's probably part of the CCNRs. Now, that's getting a little different the last few years, probably about the last decade in California, because we have droughts and then you can't force people to plant new stuff. But take a look. Go look and see how big everyone's driveway is. Look to see if there are any 2 stories. In some communities, they do have mixed story residences, but for the most part, you're gonna get people who have the same, if they're 2 stories, you're gonna see a lot of 2 stories. If it's all single stories, you're probably not gonna see the 1-2 story, right? Especially if we start running into places that have views, right? Are you gonna put a 2-story house in front of my house if you're the only house between me and the mountains? Not unless you want it burned down. Nope, absolutely not, right? Or what else do you do? What else do you do to insulate people from making mistakes like that? If you're the neighbor.
Injunction.
Oh yeah, I was thinking a little bit easier. You go run for the board. But yes, and what approach would you use to get that injunction? Why?
Because you're looking for an injunction, not money.
Right. Precisely. You're looking for injunctive relief. You're looking for somebody to get them to stop or to start doing something, right? Depends on whether or not it's a negative or a affirmative covenant. By the way, don't miss that part of it. You want to be able to identify whether or not these people are promising to do something or not do something. These are the easy points, right? Is it an affirmative or negative covenant? It doesn't change the approach on benefit or burden or benefit, but it does add the extra characterization, so to speak. Now I know, is this a affirmative or negative easement? Okay. So again, 3 forms of notice: actual notice, meaning the defendant had literal knowledge of the promises in the prior deeds; inquiry notice, meaning the neighborhood conforms to the common restrictions. What does that mean? It means every house is going to be of some neutral color palette in that example, right? You're not going to have a hot pink house. That's inquiry notice. You're going to walk around and be able to see, hey, that seems a little weird. Record notice, meaning that the form of notice sometimes imputed to buyers on the basis of the public documents. Now, this is a split of authority. Some take the view that the subsequent buyer is on record notice of the contents of prior deeds transferred to others by a common grantor. Meaning, not only should I be looking at my title or my deed, my prior deed, but I should look at all the other deeds that were transferred by the common grantor, so the original subdivider. That's significantly more obligation, isn't it? The better view taken by other courts is that the subsequent buyer does not have record notice of the contents of those prior deeds transferred to others by the common grantor. Meaning, I only have to make sure of what's contained in the prior deeds as to my lot, not in every lot that was conveyed by the same grantor, right? So let me give you this example. Beezer Homes, right? That's the grantor. This is the grantee, right? In some jurisdictions, it would require that every deed that was conveyed by the same grantor to each one of these people, I would have to do a search of. I would have to have knowledge about each one of those. The better view and more commonly accepted view is that I only have to have knowledge about the prior deeds on my property. Much less labor intensive, don't you think? All right. What's the one defense to a common scheme?
It's my land.
It's your land that you bought in a subdivision. So it's your land and you can do with it what we say is okay for you to do with it. Or you can do with it what you want within the confines of the rules of what we say is okay.
Like California.
Not public policy. I guess you could lean into public policy, but no.
Neighborhood changes?
Neighborhood changes, right? What kind of changes? We're talking about changed conditions. The changed circumstances alleged by the party seeking the release from the terms of the equitable servitude must be so pervasive that the entire area has changed. It is never sufficient to have just mere pockets of limited change. For example, let's say this subdivision is 25 years old. 25 years ago, what were garage doors made of? Wood. What did we find out happened to wood garage doors? What happens to them after some time? They erode, they sag, right? Because they absorb the elements and then you pull the thing up and what, it's always swayed in the center, right? So what did we start transitioning to? Aluminum or something like that, right? And we had the roll-up ones. They weren't really ones that like lifted, right? So we went from the big wooden ones that were, you know, kind of raised up, were real heavy, to aluminum roll-up garages. So at a certain point, these companies just stopped developing wood garage doors, right? So what are you gonna do? You're gonna require somebody to go put up a wood garage door that they don't make or recommend anymore because they don't last? No. You're gonna let them start using the aluminum. And then at some point, each one of these all have aluminum garage doors. Do you think that you're still gonna require these people to keep the wood? No. Why? Because it's such a pervasive change as to show a changed condition of the community. Oftentimes you're going to find that this is by way of material or some kind of aesthetic. Okay? Let me give you another example. We use different material now in the exterior of the home sometimes. Perhaps they've developed a different kind of stucco, right? Stucco of 30 years ago might not be the stucco of today. Okay? We used to use lead-based paint. Do you think we use lead-based paint anymore? No, we really try not to. Why? Because for some reasons kids eat it. Right? Isn't that so bizarre when you hear about this and a little kid was chewing on the wall? Why? Why? It's so bizarre, but do I want my kid eating lead paint off the wall? No, I don't. So we're not gonna require people to use that anymore. Okay, so sometimes these are, for public policy reasons, changes that occur within the community. Sometimes it's just because we've developed better products. Again, we don't use a wood garage door anymore. So something to be mindful of. Change conditions, that's gonna be the one equitable defense under the common scheme doctrine. Again, what if 2 of the 12 people had changed? Do you think you've got a very strong argument? Probably not the strongest argument, okay argument, but not the strongest argument, because it's not so pervasive, right? Mere pockets of change are not sufficient. All right. That is covenants, equitable servitudes, and common scheme, and the one equitable defense to common scheme, change conditions. All right? Okay. I think that's going to make going through the cases a little bit easier for you. I hope. If not, then I've done you a disservice.
All right, not worried about that. Okay. So before we get into some, so before we get into some cases, I just want to show you one thing real quick though, and it's just something that when I was a law student, I just couldn't quite get it. It's one of those weird things, and then someone drew it out for me, and I said, hey, and then it seemed really obvious. So let me try to do that too. And it's actually pretty important because it tells you, see, it's interesting, even when you look at this first case that we have today, that's what I want to tell you now, Gallagher versus Bell, notice that the trial court goes for Bell on this contract. And if this were just contract law, probably right. But real property law is not contract law. It subsumes contract law, but it treats it differently because contracts are so important to, contracts are important. The sale of land, the transfer of land, whatever you want to call it, is so important to society that we just have additional rules for it. And also, just because of the nature of land, it creates a lot of problems that you just don't have with personal property. You just don't. I mean, it's that kind of thing where, personal property is like, possessions 9/10 of the law. Great, let's go. That works, believe it or not. Start there and work out. It's not a problem. Real property? Not so much. That's going to be problematic, particularly when you get into covenants, which again is a fancy word for agreement, or it's a fancy, if you go way, way back through history, it was a promise to God. It was a covenant. So you covenanted to God. Today you covenant with your landlord. I don't know why. That makes me scared, but it should. Anyways, what that said, that's why I love real property, But the thing that used to always get me was this thing about horizontal and vertical privity. I mean, for whatever reason, students have a lot of trouble with that, as I did. Same thing, it's like, what is it and why do I need it? Well, if you're talking about real contracts, it's not very difficult because it's just written into them. And again, when you're moving personal property along, you can see where it goes. You know what it's going to do, and you don't have the same restrictions, et cetera, et cetera. But with real property, this type of problem happens all the time. Okay, so here you have A, okay? And here you have B. So let me show you how it kind of works and why it's a little bit different than contract law. Okay, so we have A and we have B, all right? And then we have C up here. Okay, now under contract law, all right? Under contract law, A will sell to B. Okay, so here's your deed, right? No problem. And B will be bound by the contract, right? That's not a problem. Why would that be a problem? Right? We know all about stuff like that. That's easy. The problem happens is when B sells to C. So you see how here we have horizontal, very rarely a problem. But the problem with C happens when, how is it that we are expecting C to actually live under the same restrictions or to get the same benefits as A gave B, when B, of course, mistakenly in the deed forgets to put them down. Right?
This is gonna look
Why?
very similar to the
How?
type of diagram that you would, or, setting that you would put together for assignments and subleases too.
Same kind of thing, signing something very, very similar. It's like subleasing is not in privity with the landlord. They just aren't. That's why it's called a sublease, right? If it's an assignment, all of the interest and magically, oh, all of a sudden they're in privity, right? But if it's anything less than that, it's not. And the sublessee may not even know or care who the landlord is, quite frankly, unless something breaks in. So it's the same very similar thing. So how is it though that C, let's say C wants the benefit of something, some restriction, right? That he wants to continue. It's not in the deed between B and C, but it's in the deed between A and B, right? And C would now like to use that covenant, whatever it was, that is in this deed, but not in this deed. Okay, so it is here.
You
Can't do that.
don't have to change it to eraser if you use the actual eraser I just
really?
found.
Hey,
I noticed that as I was writing today, I was like, oh,
that's very cool.
funny.
I like that.
Learn something new every day, we say.
So it's in this deed, no problem, but it's not in this one. It's not there. Okay, so I know that sounds good. Yeah, I've been playing with my emojis. I know that one now. Anyways, so,
I just want to know why some people have green emoji check marks and mine's just black.
oh, I have green.
I don't know how to change it.
Let me look into that.
Thank you.
I am becoming an emoji mascot. Anyways, with that said, so how is that it works that way? Well, if these contracts were personal, it wouldn't. Isn't that so? If they were personal to these people, it would not run to that because it's not in there. But if you go through the requirements, it's not as crazy as it seems, you'll see that in the best interest of society, that these covenants don't run with the individuals, they run with land. And if they run with the land, the whole point is you don't need that. Because you're following the land, you're not following the people. Get it? So that's why we do it that way. And the only time, I'm just giving you a heads up, I can't say it's impossible to write a question that can come up with some crazy scenario. But 99.9% of the time, this will work just fine, right? As long as you've got pieces of paper going around and whatever else have you, you're almost always going to find that the whatever just does run with the land. And again, the reason why is because it's a public policy issue. It just is better for society if it does. But what's the one thing that if you do see it in this mix, what is the one thing that does throw it off? And you'll probably find that in fact, nothing much is running with the land because it really does lack privity. There's just no privity between certain parties. What would that be? What would that little fly in the ointment be when you look down and go, I don't know if that's going to work. I mean, 99% of the time it works fine as long as people are just sending deeds around and whatever it is. But when does it not work? It's only really one scenario that comes up.
We talked about it earlier.
Yeah, we did. That's what I'm saying. I'm not telling you because we talked about it. And it's true. If you ever see it in an exam question or in the bar, it's the only one that really messes this up. Otherwise, you're going to have it like 99% of the time. And that is what? Because you truly do lack privity with anyone. And in fact, I would argue to you that all of a sudden the element becomes very important because you realize by definition, there is absolutely no possibility of agreement here. Therefore, there cannot be privity. And that's what?
When it was oral?
No, when you acquire by adverse
Yeah,
possession.
it's because it's a non-hostile nexus.
Right. It has to be, contracts have to have agreements, right? When you adversely acquire property, right, you are hostile. You in fact have no agreement with the person who you're taking the land from. Yeah. So see how that works? So it's really not that weird. I mean, when you think about it, and when you start to realize just how many people believe things, everyone thinks that they just copy the same deed and go forward. That's not true, okay? I've seen so many deeds over the years. This one has it, this one doesn't. And then you're going around like this, and then all of a sudden the land is adversely possessed, and you're like, ah. So what's the actual rule? If you learn nothing else in this class, what are the two things you will do personally, and you will always have your clients do, no matter what. Whenever you buy, sell, or even spit on property, quite frankly, what are you going to have done? What?
Put a fence. I don't know. Put a fence.
Sorry. Nope. What?
Oh.
Title search. And what are you going to buy? Insurance.
We literally do
Not
like
not do it.
a week or two on title insurance. And you know what the rule is at the end of the week or two? Always advise your client to have title insurance. Always.
Never say it's okay, because you're going to get burned on that one, and that's malpractice. So do not do that. I've had all these people come and say, "Oh, we're just going to use this one-page thing. We're just going to do this. He's a really good guy." I cannot advise you to do that because you're an idiot.
And you know what you're gonna do?
Sorry.
You're gonna write all that up and be like, I have advised you
Oh, yeah.
of the need and recommendation of title insurance. You are waiving title insurance knowingly, intelligently, and voluntarily. And in, I suppose, in contradiction to the advice that's been given by counsel. And then you're gonna have to sign it, you're gonna have to date it, you're gonna have to print their name next to their signature to make sure it's them. Probably gonna do it in front of a notary. I mean, you're going to cover your behind because you do not want to lose your bar card or all of your money because.
Well, I mean, I can't even say it's a rookie mistake. Most rookies, you don't do that. It's insanity. It just is, because you never know what you're gonna find back in. I mean, do you really want to stake your career based on what some other Shylock lawyer did for somebody? You're out of your mind. I can't even imagine doing that at this stage. But, and it's always for the same reason. Well, he doesn't want to make a big deal out of it. It's going to be cheaper this way, da-da-da-da-da. How much
Let me
do you
just
want
tell
to
you.
bet you can't even tell me whether this guy selling it to you even owns the land? Have you even looked it up? You think people are above selling land they don't own?
Wait till next semester. You're gonna find out no. And where do they all go? Costa Rica. I said that so many times. Dean Drucker was like, I'm gonna go to Costa Rica. So I went to Costa Rica.
And I have to report that it's a lovely place. And you can sit on the beach with your tunes and your margaritas. And should the need ever arise, I know where I'm going. That's all I'll say. Yep.
That lady just killed in Costa Rica. She was by herself. Did you see that story?
Mm-hmm.
She was there for a birthday party. She left her sister-in-law, went home one day early. She's like, I'm gonna stay here by myself. It's one more day. Well, not a good idea. She was murdered by allegedly a security guard.
Costa Rica?
Yeah.
Uh-huh.
Oh man, they're just the
It
nicest
looks like a
people.
nice animal.
Wow. I find that hard to believe. Wow.
They found her in a shallow grave wrapped in
Oh,
plastic.
really?
So you have to figure she didn't fall down and hit her head and like a tree fell on her, right? So
And then she magically wrapped herself in crackers.
yeah.
That's the one I was like. Yeah.
Mm.
She shot herself in the back, huh? I've heard it all.
Well, the scary part is that they talk to like the Uber driver, the people who run the Airbnb, the security guard. They talk to like 3 or 4 people and they all have the same story. That she left really early in the morning, even though her flight was super late. So it's gonna be bizarre because it sounds to me like they were covering up for him or had something to do with it as well, unless they, like misidentified what happened there. Scary. Gotta be careful when you're traveling abroad.
It's true, it is dangerous.
All right.
Not Costa Rica. I'll take my
So, who would like to, by the way, one of the cases that we've done is, we've previously done, so it shouldn't be too difficult. Traditional elements of real covenants, Gallagher versus Bell.
Well, and there's your answer. You need to tell me whether that indemnity agreement runs with the land or if it's personal to a person, right? Isn't that the issue?
Personal versus.
That's how it works. I mean, that's exactly how it works. So let's just take horizontal and vertical privity off the table. Okay, after today, if you don't understand by the end of the day, let us know. Okay, because I want to, getting this one out of the way, you know, I really wish, thinking back now, that I would have gotten it out of the way, because it was always just bugging me for weeks. So, okay.
So, Gallagher versus Bell, closed special appeals in Maryland, 1986. Covenants, in 1960, Mr. and Mrs. Gallagher bought an 18th century tenant house that was situated on half acre of land in Montgomery County, Maryland. It sat in the middle of a tract of land that was now owned by the Bells, who bought a portion of the land from the Sisters group. I mean sisters by like Americans, I'm assuming. And by the Franciscans. It was understood that the Bells bought the land to build a subdivision on it. The contract indicated the Gallagher's home was not part of the contract, not part of where the subdivision would be built. They agreed to split the cost of a road to be built between the Bells property and a public way. In 1979, the Gallagher's sell their property to the Cavaliers, to Miss Cavalier, and when she finds out about the agreement by the Gallaghers to pay for the road, she insists on an indemnity from the Gallaghers. Well, the Bells start building the road in 1983 and demand that Miss Cavalier pays $18,000 as her share. She refuses, but she says she has an indemnity agreement with the Gallaghers, so the Bells file a lawsuit against the Gallaghers. They argue that the covenant they made in 1961 was a covenant that ran with the land, and that the liability on it terminated when they conveyed the property to Miss Cavalier. A jury awarded the Bells $7,000. On appeal, the Gallaghers argued that the issue was an issue of law to be decided by the court, not a jury, and that the court should have declared the covenant to run with the land, and in doing so, their liability under it ended when they conveyed the property to Miss Cavalier. The appeals court reversed the lower court decision and ruled in favor of the Gallaghers. So the issue was, did the covenant run with the land or was it a personal issue? And the rule was, it ruled in favor of the Gallaghers, meaning it ran with the land. The case really went into defining the elements of the covenant that runs the land.
Okay, that's true.
So I just wrote down the 4 elements here, but they went into just all the detail of the elements in the case of the covenant.
Okay, and so they pretty much found that they had made all the elements, right?
Right.
Okay, and because of that, they reversed the decision.
They reversed it,
They decide that in fact, this indemnity agreement runs with the land, right? And it's not personal to the Gallaghers or anything like that. Now, it's interesting to note though, let's say that this was not a contract for the sale of land. Well, it was the sale of something else and then you signed an indemnity agreement. Under typical contract law, is it possible that the indemnity agreement, I'm not saying it would be, I think this is where the trial court kind of went, but couldn't it be possible that this was actually a separate agreement that would survive even if in fact the sale of the land didn't go through? Or, I mean, if the sale of the land would have to go through, but could this be considered a separate contract that wasn't actually tied to the land, doesn't actually touch and concern the land, it's just a indemnity agreement? So it's like, because what you'll see, you haven't had it yet, but you can sign a contract for the sale of a home, and then you can sign another contract, and if that contract can be performed independently of the actual sale of the property, that might survive. That actually might keep going because it just sort of breaks off from the contract for the sale of land and it goes on its own. And I think that's where the trial court was going. Otherwise, I can't figure out how they came to that decision. So in many, many ways, this is really just a contract case. Right? It's just a contract case. But what's interesting about this case is even though the contract, looks like they're in privity, looks like da-da-da, looks like this, looks like that, when it comes to real property though, you've got to stop and say, but wait a minute, because it's real property, right? I mean, this is the only place we use this. We don't use it in any other type of property, but because it's real property, it looks like it's personal, it looks like a good contract, but in fact, we still have to go through to see whether this agreement or covenant, whatever promise it is, runs with the land. Because if it does, it's gonna go forward. And so that's different than what we would consider, black letter common contract law. So that's why covenants, that's why you really have to go through it. Because it's not best out of 6 or best out of 5 or whatever. People use different tests for it. It's you have to have them all. But you see how you have them all, you get out of basic, get out of this house. But you could take advantage of this doctrine or how we do real property law. See? I mean, there's no such thing as personal. I mean, I can't say there's no such thing, actually. It is possible, but it's very, very rare when you have personal property that runs with the land. I mean, how would that work? It could if you're on a farm or something, I guess.
I was just thinking maybe like major equipment.
Yeah, it's possible.
Mhm.
Maybe a silo or something. I think they argue about those, depending on how they're put in the land and stuff. Yeah, but generally speaking, it is sort of like okay, you did that analysis, but make sure you did this one too. Because I think that's what went wrong, was I think the trial court never quite got there. So.
I thought it was interesting that Gallagher, but I mean, lucky for Gallagher, that the fellows didn't build a road for 22 years.
Yeah, I mean, that's why I'm saying this. I know this one.
He's smart to.
It's it's an interesting case, but it really shows you why you have to know this, because it's really important. I mean, again, most of the time, these covenants will run with the land. Most of the time, the only other thing you really have to really watch out for is you do have buyers who genuinely really do have no notice. It does happen from time to time. And of course, if fraud's involved, I have to say this the wrong way. Yes, if fraud's involved, it's going to change the whole thing if people are purposely hiding things from you.
Why do you think they do that sometimes? Don't you think a burden piece of land might be less attractive or appraised differently than something that doesn't carry that burden? If they want to get a higher rate for the property or higher market value, they might, fraudulently conceal something like that.
Yes, and omission doesn't work. Okay, just so we're clear. It's like, well, I just won't tell them about that oil field out in the North 40. Yeah, you better tell them. One of those things. So, but that's true. It's about market value for the most part. They'll try to get a higher, either an appraisal value or just a higher price. So, and it's every time your land has any encumbrance, theoretically the price goes down, right? I mean, there's no really such thing as an encumbrance which brings you money. It's like, again, this is the land that's being burdened, not benefited. So these encumbrances are not good. They lower the price. So, but again, the question becomes, if you're getting a really good deal, right? Sometimes you got to think to yourself,
Is it too good to be true?
Why am I getting this good deal? And a lot of times that's what it is. Believe it or not, is oh yeah, I just need to get rid of it. Do a title search.
Yeah, why?
You see what I'm saying? There's so many pitfalls to buying and selling property. I can't, nobody can listen to me. It's just not possible. Whatever you think the human mind can come up with, someone thought of something way more devious that I pray none of you ever think of, quite frankly. Crazy, particularly when it comes to land, people get really weird.
This is why in the capacity of criminal law, defense attorneys make the hardest judges. Because you've heard everything by the time you get there, right? You've had every excuse given to you. You've heard every explanation, every justification. So they make difficult judges. Well, I don't think so.
Yeah, I don't really think he gave you his car, his credit cards, all of his cash right before he shot himself in the back of the head. I don't think so.
He's a really nice guy.
I've actually had people say that to me. He's a really good friend of mine, a nice guy.
My favorite is, I'm driving the stolen car, John gave it to me. John who? I don't know his last name, I've known him for a while. Oh, how long have you known him? I don't know, maybe like 2 months. Where does he live? Somewhere over there, but I don't remember the exact street. Well, if we drove you by there, could you pick out the house? I'm not sure, it was kind of dark. Okay, but you know this guy well enough to that he let you have his car.
No problem.
What about that shaved key or the fact that the ignition's punched or what, you know, I don't know. It's like a great cops episode, right?
And then, of course, I think he's visiting his relatives in North Carolina. No, we found him in a ditch. John!
Yeah.
Yeah. I used to, when I was dean at Abraham Lincoln, we used to get letters like that from the prisoners all the time, telling us that again, I'm not picking on people. Yeah, kind of am. Anyways, but it'd be like, you must prevent this miscarriage of justice. And you're sitting there, they caught you riding around in his car with his credit cards and his cash. He's lying in a ditch and fill in the blanks. You don't really know who he is, blah, blah, blah. Oh, and then again, what's the other one you find out is that he owed you money for some drug deal that went bad. Yeah, okay. Well, then. Now here's someone who actually has valuable talents. Yes.
He's handsome too. Dibs. Just kidding. Right?
Absolutely.
His wedding ring finger actually says taken on it.
Yeah, he has a little tattoo, right? Yeah, that's cool.
It does. And because you're law students, you'll appreciate this. Right under his sleeve, my bar number. And for any Friends fans, lobster clubs. It's a thing. I'll show it to you guys. It's a thing. All right. So, do you want to try one more before we go? I think we should.
Yeah, sure.
All right.
I mean, give me the facts and we can move on.
If you guys can apply the facts and the rules to the approach, then we move forward very quickly. Okay?
Next is Neponset Property Owners Association, is that right?
If he falls through the roof right now, I'm gonna freak out.
Yeah, I probably wouldn't be standing that close to that.
Well, this is not anything he's gonna fall
Yeah,
through.
no, I know. Same.
I mean, I'll catch him.
Yeah, you should catch it.
How do you know?
He's strolling around like he's on the second floor of like a, some building randomly. Just cruising.
Yeah, I always just can't help but think about Alien whenever someone does that. Oh,
All right. Let's go through Neoposit. Ponsit.
That's pretty straightforward.
I'll try this.
Yes, ma'am.
This reminds me of an association, I guess the first association.
Okay.
Yeah, I didn't know it went back that far, but it's a 1938 case. And it's, I have here that in January of 1911, how do you say that?
Neponset.
Neponset were the owners of the land. And they were selling tracts as residential communities. And part of that, they had, they sold a piece of the land to a Mr. and Mrs. Dyer. And it also contained a covenant on there where if they had to pay $4 a year to, and that's where I see the association. And that's part of the $4 a year was to maintain roads and parks and beaches and things like that, paths or whatever.
Which again, put this in context of time, right?
Right, and that's where, and then it was, the land was sold. So, and then nothing was paid. So what I got out of it was that this money that was not paid was becoming a lien, was placed as a lien on the land. And the defendant was alleging that they were trying to say that this was not part of it, that they didn't know anything, about this, that they shouldn't be paying this, so they were trying to get out of from foreclosing they were trying to foreclose the lien on.
Right, so
on
as a
the-
practical matter, if you are a homeowner and the homeowners association says, well, they haven't paid their dues, I think in well, at least our CCNRs, but I think in California, it's pretty much 12 months or like $1,800. And you can foreclose on somebody's home. You can place a lien on their home and then you can actually foreclose. So who wants to lose their entire home or not, potentially lose their home or a piece of their home as a result? So as a practical matter, what they're saying is, does this run with the land, right? And should they be obligated? Have they, shirked some responsibility that they were required to comply with?
And they did talk about the vertical privity, they were trying to say that they were not in privity. of
And
this.
because they were successor owners, right?
Right, so that was part of the issue was, are they in privity of this, estate, and can this be enforced upon them, of this restricted covenant that they had? So, I had here that the court, after going through all this analysis, they were in privity of the estate, and the order was affirmed with the cost, so they did have to pay for the cost of that.
Kind of like that.
Okay.
That look great to everybody? Again, not terribly difficult taste, but it's again kind of weird because anything else?
No, that's it.
Okay, and how did this? I'm
I
sorry.
didn't know that they could,
Who won this case, by the way?
Oh, it's affirmed.
they ended up having to pay because the judge said that, the court said that they were in privity between the plaintiff and the defendant were in privity, and they would have to pay the cost.
Right, so the bottom line is, and again, what is kind of interesting is it's being transferred by judicial sale, right? So what does that mean? Anyone know? You should know that, maybe in this class.
It was like, maybe ordered in a judgment or something
Yeah.
to be sold?
Someone got a judgment against them, and in order to satisfy the judgment, they ordered a judicial sale, okay, to sell the house. Now, it just so happens that very interestingly, again, Professor AJ said this, which is really good to know out here, is that everyone thinks, oh, this association, they fined me $1,000, I'm not gonna pay it because, I'm a landowner and that means that, I have unbelievable rights and nobody could ever tell me what to do. And I wanted my house to be purple and I'm not feeling black, whatever it is. The bar at which they can have you, they can force you to sell your house at judicial is really low. Most
It is.
people don't realize that. It's not like in the hundreds of thousands of dollars.
We've had to do it. I'm
Yeah.
on my HOA board. We had people who just said, we're just not gonna pay HOA dues.
And guess what? It's like 800, it's like, for many, many years, it was, I can't remember what it was, but it's like $1,800.
Yeah, we had to do it at one point because somebody owed us like a few $1,000s and they were just living without paying any of their HOA dues for years. So, I mean, we have, in my community, HOA dues are like $100. We don't have a lot of common areas, so it's $100. It's actually a little bit under $100. They got up to about $2,700, and you're talking about over 2 years of just saying, forget you. And everybody else is carrying their burden. Right.
Which is great, because that's the other thing that this case.
But
teaches you.
they were also benefiting from gates that worked, streets that were paved,
Yeah, all that stuff.
all the sprinklers that were in the front, all the flowers that were being replanted. They were benefiting from the beauty of all the stuff, all of the working facilities, but they didn't want to pay for it. Right? So if you think of it from that perspective, it's not fair for everybody else to have to carry that load.
Right. And the other thing that this case tells you about, which again, I think is good to know out here, is so when push comes to shove though, one of the reasons they can do this is because does the HOA, is that really the party that's can enforce this judicial sale for even for like non-payment of HOA dues? Yes or no?
Yes.
No.
Yeah, no.
No, who, the HOA is just a convenience for who? Think about it.
The court.
Although the court likes
To
it,
the actual owner.
the actual owners, all the other owners are actually owed this. It's not the HOA. The HOA is just a mechanism that the owners approve of to do these things for them.
On
So-
their behalf.
Yeah, so you see, so don't sit around and go HOA, look to your neighbors and, go stab them. HOA is just, it is an entity, but it's not the representative entity. That's why partly they can do that. So again, good to know out here. Don't go picking on your HOA. They're just theoretically enforcing what everybody else has agreed to do. So it's their rights to enforce this upon you as a fellow homeowner. Got it? So remember that. It's actually a really good thing to know, because they'll try to blame it on the HOA. Pull it out. Doesn't matter.
Right? All right, come back at 10 minutes to 8.
Excellent.
See you back shortly. This is like the adult finish, right?
Yeah.
You should see that. Jury. What if people think no, I'm sure. Like they were texting me. They took 15 minutes to finish my training. What is this? Oh, it's just a freaking highlight.
Oh my God, you don't have to tell me
No, no. I was trying to do that with my other job, but I was like, that was my plan to go lots of work for it for long enough, but the name that came to me. That was my plan, but then never got like, settled down anymore. I didn't find what I wanted to say.
A lot of times they make you, if they pay, they have you commit that you have to work for them.
Oh, yeah, for sure, that's a given. If you don't, shoots, you owe them money. That's for sure. Actually, it was a gift. But there's all of these like, exceptions, right? Detrimental lives.
So when we were at Baby Bird, that's what Sheila told me. That I was
Damn,
like,
Sheila, that was what.
She knows it. But I think,
Just funny. Just funny.
I think they're friends or something like that.
Yeah, they do. Love Sheila.
She was going to a hard time though because her boyfriend didn't want her to. Her boyfriend didn't want her to go. He didn't
Sheila's
want her-
boyfriend?
No, no. She was.
Yeah, she's right. Okay, it's like, what's
The
his
other
name?
one.
Robin?
No, the one that.
Listen.
Yeah.
What's
He didn't
his-
want her to come. He got kind of jealous. She was spending all her time.
Oh, obviously, he should know.
I know, but
Jerk. What a jerk.
Is this one of your classmates in the first year?
no, this was second year, so she's a grade ahead.
Oh, okay.
So she'll be coming,
This is third year.
she passed baby bar in June,
Oh.
but she didn't start the third year this year, so she's gonna
Oh, I
next year.
see.
She'll be, so. She'll be starting, I'm gonna say with you guys, hopefully I pass, so, she's starting with us the third year. So,
Oh, interesting.
yeah, but she worked at a law firm, and when I was, at the baby bar, another person, Sheila told me that she had lost her job. So she was looking for a job so she can pay for school.
So you're saying that if you work for a firm that often they'll pay for your school?
Sometimes they do,
If,
yeah,
if the, they offer it,
they offer, sometimes they do.
yeah, I mean, at the end, if it's in the budget, and of course, getting to work for them at the PM, of course.
It's fine.
Yeah.
You could do that.
Some people do that.
Yeah, that was my plan, but never found one I wanted to be.
Yeah, I don't know how well they pay either.
It's like that's a stress, out of your, off your shoulders. That's the monetary,
Well, that's true, then they pay for law school.
now you're just really gonna come in, get good grades.
Yeah.
Amazing.
I don't know, working with Walter Clark is like,
What was like,
when he's working.
the people I'm spoken with, they seem pretty happy.
Yeah?
Yeah, I mean, I've never heard them complain about their jobs. I know two people that work there.
Do you?
Well, there's one that came to the baby bar. I forgot her name.
I know, that's what I'm saying,
You know who
I know,
she is. And then
Walter Clark?
Walter Clark, yeah.
Sevens, called Sevens.
Oh, you
If you're
might-
injured, oh, do you have it?
You might not get injured, San Bernardino.
Oh,
Although,
yeah,
but he does advertise out there.
because it's
Big personal injury attorney out here.
yeah. It's,
I don't know.
He's got great commercials, he really does.
someone did a spoof. You should ask Kelly.
Oh,
Someone
really?
did
Oh, that's funny.
parody of it. It was so dirty.
Oh, like,
Well, it's funny and dirty. It's hilarious.
was it like, because the kid?
You can't. If you get your key stuck in the phone, call me.
Call the clerk.
Once it all ends,
I'm gonna have to pay attention to the billboards, cause I don't know who he is.
Yeah, it's in Spanish too, a lot of it.
Oh, really?
Yeah, because you know, bilinguals. That's the value.
Great phone number.
You can't forget it.
What is it, 7777777?
Seven.
All seven.
It's also call at the sevens.
I have to pay attention.
And it's a phone number.
And he's got a great ad where he sponsors schools, and he'll,
Probably.
it's like it almost looks like a PSA, public service announcement, but it's really a commercial, but he looks like, you know, this amazing person, he's helping the schools, and it's good, it's really good. I think it's good. That's all about advertisement.
I'm just kind of curious to find out what they're gonna do, because, we have you know, these guys, all these people that are gonna be fingerprinted.
Oh, yeah.
We have some in workers' comp that have to shave.
Oh, seriously?
So it's like, I wonder what they're gonna do with them.
Well, there's some interesting stories coming.
I know.
That's so funny, because I always think, if you're smart enough to pass the bar, and if you're, you know, studious enough to go through law school, that you got your head on straight.
I always think, why would they do something like this? You know, they work
Yeah,
all those years to get to a license.
Yeah.
And then you do nothing. You know.
That's scary.
I made a mistake today of switching the time that I was gonna go to a workout class and saying, it's an advanced class, but it's the same instructor, how much different could it be? Took me about 30 minutes afterwards, just, I don't know what this meant, 30 minutes afterwards, after my brain's out, to start feeling the soreness. And I was like, ooh,
Wait till
That's-
you wake up.
give me 2 mornings from now.
Wow.
That's gonna be painful. I was like,
That's Pilates?
mm-hmm. But it was like, I don't know, they did an advanced class, and so I was like, okay, this is a little different, that's a little more aggressive. So we're gonna add some weights too, and do this, do that. Okay. All right. Let's do this, but do it on a Bosu ball. You guys know what a Bosu ball is?
Yeah.
Got like a flat bottom, and then it's
yeah,
like a rounded top,
Yeah.
and it's like
Yeah.
a ball, right?
Yeah.
So we're doing different exercises with our feet on the ball rather than on a flat surface. So you're having to like, that was a good time. It's kind of fun until you almost fall. Then it gets real fun. All right, I'm gonna take a peek for Professor Drucker, and if he's not out there, we'll just get started and he can join us, but. Let's see if I can coax it in. They were gone before we went to break. All right, folks. Back at it.
Sorry about that.
Tulk versus Moxe.
Hey, yeah, here we go. To jolly old.
Notice what category it's under. Equitable servitude. What do you think case is about? No joke. It's funny that you say that. We literally had an exam that was an easements question,
Oh, yeah.
but it was on a final. And the word easements was used, not once, not twice, not 3 times. How many times do you think it was used?
5. 8
times in the exam. And people did not write on easements, all of them. I was like, we're literally not trying to confuse you and have you talk about covenants. We use the word easements 8 times. What's the rule? If some exam has the word easements in it 8 times, probably want to write about easements. We had one person who did not write about easements. They did not pass the exam.
Well, I can't quite pass you for that.
No.
It's pretty hard.
All right. So let's talk about the Lord Chancellor.
Moxie?
Yeah.
Okay, so the plaintiff Tolk owned several pieces of land in Leicester Square, and he sold the Leicester,
Lester.
Leicester. Like,
We jokingly say when we go to London, we call it Leicester Square as a joke, but it's Leicester Square.
Leicester.
Uh-huh.
Okay.
But you wouldn't know that if you didn't know that, because it's not spelled that way.
So he sold the Leicester Square Garden or pleasure ground to Elms, with the covenant stating that Elms, his heirs and assigns should and would from time to time, and at all times thereafter, at his own and their costs and charges, keep and maintain the said piece of ground and square garden, the iron railing around the same in its then form, and in sufficient proper repair as the square garden and pleasure ground. Elm then sold the property to Moxie, which is the defendant. Defendant purchased the deed, but the deed did not have the language of the covenant, but he was aware of it at the time of purchase. The defendant wanted to build on the land, and he asserted the right to do so. So the plaintiff filed an injunction, and the injunction was granted by the master of the rolls. No idea who that is. Defendant filed motion to discharge that order. So for my issue, I have whether a party shall be permitted to use the land in a manner inconsistent with the contract entered into by his vendor and with notice of which he purchased. The rule, I have it at the bottom of page 635. The court will enforce a covenant against the party purchasing with notice of the covenant, or an inequity is attached to the property by the owner. No one purchasing with notice of that equity can stand in a different situation from the party from whom he purchased. So basically they said that one cannot choose to not honor the covenant, because then the price would be affected. And they said that nothing would be more, could be more inequitable than the original purchaser should be able to sell the property the next day for a greater price in consideration of the assignee being allowed to escape from the liability which he himself had undertaken. So he can't benefit from the bargain and then, not, and just choose to ignore it and then sell it to make money off of it. So the injunction would not be discharged and they affirmed it.
So what do we learn from this case?
That even if the language is not within the deed, if you knew at the time, it will be honored.
So
As long as. That's not necessarily true, even according to this case. As long as what? Not to interrupt, but this is actually really important.
well, what are the elements of an equitable servitude?
That they have to have the knowledge.
There you
It's
go.
one of them. Writing, intent, touch and concern, notice. Right? Remember witness, right?
Mhm.
WITNES.
Yes.
Like almost correct, right? But it's as close as we're gonna get. So, what do you think the issue is then?
Was it in the writing?
Well, it wasn't in the writing. We know that, right?
Mhm.
Well, let me just back up one step, maybe. Because this is a very old case anyway, so let me, notice that, where are we? We're in, and I don't mean anymore. We're in the Court of Chancery. What does that mean? Chancery is another word for what? No.
Court of Equity.
Yes, it's the Court of Equity. Because back in those days, the court of law and the court of equity were separate. You didn't bring both cases at the same time. So we've already been through the court of law. Got it? That's gone, right? He lost in law. They said, I'm not gonna do that for you. Now they're in the court of equity and he's trying to get this injunction lifted, okay? And so he's saying, fill in the blank, right? Right? And it doesn't say this in my deed, therefore why should I be held to it? So in the interest of notice that the entire case is posited about things being fair. Okay, that's another way you're always gonna know you're in an equitable court, because they're not gonna talk about the law, they're just gonna talk about what's fair, particularly in these days when they were very, very separate things. So what does this, I would say that in this case, that you're correct, except I think that the court is making a point about one of the elements that really is very, very important, even in a court of equity. Okay, it's not in the deed, but
The public policy reason?
that usually works with me, but no, not this time. 99 out of 100, that will work. He had, even though it didn't say anything there, he had what?
Knowledge.
He had notice. And they make the point on the page, they say,
Mhm.
you knew about it, therefore, even though you left it out, he did leave it out of the document. Why is it fair to give you a piece of land that was discounted? And now you can turn around and do what? Sell it for a higher price.
Make a buck.
Because
That
everything-
might be an example of where in writing, it needs to be reduced to a writing, but maybe it's not contained in the writing that it was reduced to.
Yes, exactly. Because again, it has the, it goes to the statute of frauds,
Mhm.
because there is variety. So anyway, it's very close, but I think what this case really stands for is the proposition that even in equity, whether it says so in a deed or not is irrelevant.
Mhm.
I mean, it's not irrelevant. If it says it in there, then why are you here, quite frankly? But even in this situation, it had to be established that the buyer had knowledge of the restriction.
This would
It
be
says
a good
clearly
intent
equity.
discussion as well.
Yeah.
Because if that was the intention, but it wasn't reduced to the writing, I suppose you could waver on the intention, but if the facts suggest that each party negotiated this as part of it, then you need to have that as part of your discussion. By the way, so we're gonna learn or work on a skill that you're gonna need when you take the bar exam. And that is to focus even when there are distracting things happening, because there's going to be a ladder in the room shortly. It's gonna be a little bit noisy, but the bar exam, you're gonna have all kinds of noises and all kinds of craziness, and you guys know from taking previous exams. There are just a lot of things happening in the room sometimes, and you have to be uber focused on what you're doing, right? Okay. So this is just going to be a practical application of that for tonight.
That's right, because we're an academy. And straight.
Yes?
Yes.
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 Thank you.
Okay, well, good job otherwise, but again, just a point of, but more and more and more, as you keep studying real property, what you're gonna find out is that there's two rules, basic rules. If you're on the selling side, disclose, disclose, disclose,
Mhm.
disclose. If you're on the buying side, notice, notice, notice. You have notice, you have notice, don't play games.
If you're selling, there is no reason you should not be disclosing. It is the quickest way to get yourself sued
Almost the only.
or have the sale invalidated in some way.
Yeah, I mean, you can only lose by not disclosing. Because you can buy property with,
You
even
can
with-
buy a lawsuit.
Oh, yeah, definitely.
You can buy a crummy property with all kinds of things going on.
If you agree.
Yeah.
But if you don't agree, that's when all these rules kick in because you never knew. Right? You can always negotiate a lower price for an encumbrance. See, like encumbrances drive the price down. So you sit there and you get your thing and say, well, this is wonderful, except I've got 29 encumbrances on this. How much you giving me? Nothing. Goodbye. Or I'll give you, who knows, 10,000 off. Who knows what they'll do? Depends what they are. So that's how it works. So just disclose. Anyways, I told you about that one I had with the disclosure thing. The stupidest thing, I can't believe it. It was about, guy sold a house with a crack in the pool. Did I tell you about that one? He had a crack in the pool and he never admitted it, but he kind of covered it up. Well, what happened was though, is that, and he claimed that he didn't know about it, so how could he disclose it? We found out later that he did know about it, and you know how we found out? Oh, I didn't tell you this story. Because his water bill was really high, and he inquired, and they said, there's a leak somewhere on your property, and he did patch up part of it. And, you know, my client would have been like, if he told me about it, I don't know, maybe I wouldn't have bought the house, but if he had fixed it, or if he.
Or you would have asked for some concessions for it, yeah.
Maybe, you know, he said he had real nice furniture, maybe he'd throw in the furniture. And I just, you know, disclose. It's really the only way you can lose. I mean, there are other ways, but that's the easiest way. It's silly because that's the type of thing that you will go to rescission. You'll say this is the type of fraud, and you will get the entire contract canceled. So don't do that. You know, you're playing high, not high stakes, but higher stakes than most people are used to doing. Right? You're dealing with pieces of property, and so rescission kicks in, reformation kicks in. I mean, all these different things. That's where you see a lot of these equitable remedies. That's where you see a lot of these extra remedies. That's where you see specific performance as a right of law. There's no other part of the only other part of law that I know that to be true is specialty goods in the UCC. And even then, it's not a guarantee that you're going to get it. It's just available.
So,
Yeah.
The next case as well is going to be part of the equitable servitudes discussion. It's a little displeasing to the eye going through this case because like page 2 is all part of one paragraph. So it's a little daunting, but not an, you know, particularly long case, just a little displeasing. You look like you're excited to take this on. Okay. You started making movements like you were trying to figure out if you could get up before the next person.
No. But I'll do it.
Okay. Or I've just obligated you to it now.
Yes, you did. But
Accept the challenge.
yeah, that's all right. All right, so this is London County Council versus Allen, the Court of Appeal in 1914. So on January 24th, 1907, the London County Council entered into an indenture with Morris Joseph Allen, a builder who's the owner in fee simple of a piece of land. The agreement contained a covenant that both parties wouldn't erect or place any building, structure, or other erection upon the land shown by green color on the said plan without the previous consent in writing of the council to do so, and that on every conveyance, sale, charge, mortgage, lease, assignment, or other dealing with the land, he will give notice of the aforesaid covenant in every transfer of the land that I previously just mentioned. So the plots marked in green were 2 plots intended to be transferred or to be reserved for making of public roads. So in July of 1911, on plot number 1, 3 houses were built by Mrs. Allen, and on plot number 2, a wall was built by Mr. Allen. So the city council issued an order demanding that the houses be torn down, and he wanted a trial court to enforce the order.
Even in 1914, that's an expensive mistake, isn't it? Mm-hmm.
So Mrs. Allen asserted that she wasn't bound by the terms of the covenant because the city didn't own any of the land that would be benefited by the covenant. And then when that failed, she asserted that she wasn't bound by the covenant because she had no notice of the covenant at the time she acquired title. The trial court concluded that Mrs. Allen had failed to prove that she had no notice of the covenant. And they also said that the city council's interest in the construction of the streets for the public benefit sufficed to make the original covenant run with the land, even though the city didn't actually hold title or own the land that would benefit from the terms of the covenant. And then, so Mrs. Allen is appealing to this decision by the trial court. So the issue I have is whether it's essential to the doctrine of Tulp versus Moxie that the covenantee should have, at the time of the creation of the covenant and afterwards, land for the benefit of which the covenant is created, in order that the burden of the covenant may bind the signs of the land to which it relates. The rule is on page 639, and it says, If the covenant doesn't run with the land in law, its benefit can only be asserted against and assigned of the land burdened. If the covenant was made for the benefit of certain land, all or some of which remains in the possession of the covenantee of his assigned suing to enforce the covenant. So in other words, a public body should be prevented from enforcing a restriction on the use of property imposed for the public benefit against persons who bought the property knowing of the restriction when the public body doesn't own any of the land in the immediate area. So the court says that subsequent cases after Tolk have interpreted Tolk to impose a requirement on the establishment of a covenant running with the land that the covenantee hold property at the time of the covenant's execution that would benefit from the performance of the covenant and continue to hold such property at the time performance is demanded. If the covenantee never held property that would benefit from performance, the covenant will not run with the land as a matter of law. If the covenant does not run with the land as a matter of law, then it acts only as a contract between the covenantee and the original covenantor. A successor in title to the covenantor may simply ignore the obligations of the covenant, and the covenantee has no right to enforce the covenant against the successor in title. The only remedy for the covenantee lies against the original covenantor, and the judge that's writing this opinion talks about how he doesn't agree that a municipality should be prohibited from enforcing the covenant restrictions for the benefit of the public when the successor to the covenantor purchased with notice of the restrictions. So although he disagrees, he states that precedent demands the result, that the municipality should be prohibited from enforcing the covenant restrictions for the benefit of the public. So they affirmed the lower court's judgment against Mr. Allen and then reversed it against Mrs. Allen.
You like the distraction? Keep focused.
That's all I got.
Okay, sorry, I actually do this on purpose sometimes.
That's pretty good. So, just give me a short version though, what's the problem?
That
What are they discussing actually? It's actually, what does this, why is this case different than the one before it? In other words,
well, it has to do with the government coming in for the benefit of the public and trying to make the roads
okay, but what does the government not own?
the land.
No land, so it's not among landowners. But why is it that, and this is an old case, and so, they kind of said, well, back in England in those days, you had to be a landowner, right? So they overruled them. How about today? Think the law's still the same? Okay, what do they honor now? What do we call this? We don't have this problem in America.
America.
American rule is different, yeah, America rule. Because we have two types of easement, two types of obligations, I guess would be the best way to say it in the United States. We use it in easements a lot, that's why I'm thinking about it, but what do you think? In other words, I'm thinking of two words, and if you don't get it, it's okay. Nope, okay, make sure you read note number 1 next time you do this case. Anyways, in America, we have two different types of land, right? Land rights. Appurtenant, which means what?
Use a descriptive term that also starts with an A. Adjacent.
Adjacent tracts of land, right? And we also have another type of right, which we usually attach to easements, is where you usually learn about it, but it goes all over the place. Can you also have an easement in land that is personal to you? Only you can walk onto this land because the owner said you could to go fishing every year. Yes or no? The answer is yes, and we call that what? rights engross. So in America, we don't have this problem. England would have what? Or the London Council would have what? A right. Even though they don't own the land, they have the right in.
Gross.
There we go. So, and do you think the law now reflects that in England?
Yes.
Of course. There you go. Okay. So again, try to look, the reading was good, by the way, but try to look why this case is a little different than the one before. Because this case is actually used, it shows you why we have a certain in gross rights. Okay, because we don't want to have things like this happen. Okay, if it's in the best interest of, of the land or the public, whatever it is, the person, we're gonna let them do it. Okay, that's not necessary to have two landowners anymore. That's really old law. So, okay, good job. Oh, really, I like this case. Sprague versus Kimball.
That one?
Okay, yeah, it's a good case.
You said spray, is that how you said it?
Sprague. Yeah, I used to know a guy named Sprague. That's how you
Spray.
assume it's the
I
same.
just always think of Sprague from, Mr. Sprague from Little House.
Oh, yeah. I forgot
He's the
about
banker.
that. Yeah, he was the banking guy.
Okay, so
Know a little bit about a lot. Go ahead.
So this Sprague, plaintiff, Sprague owned 4 lots, 2nd, 3rd, 4th, and part of the 5th lot. It came with various restrictions on types of things and acts that can be maintained on the premises. It's very lengthy, so I'll just read a few. It says, premises are conveyed subject to the following restrictions which shall remain in force 20 years from the date hereof. No building shall be erected or maintained upon the granted premises between 23 feet of said Bassett Street. And that no public or library stable shall be maintained thereon, and they shall not be used for mechanical, manufacturing, or mercantile business. So the Kimball owned a portion of the 5th lot, and it obtained it by deed containing these same restrictions. 7 years later, Kimball conveyed the rest of Lot 5 to Grossman, but failed to include those restrictions in writing. So Sprague filed suit to enjoin Kimball's sale to Grossman for failing to include those restrictions in the writing in the conveyance. The judge found the defendant and informed the plaintiffs at the time of their respective purchases to subject the lots as they were sold to similar restrictions for the mutual advantage and protection. So that it's plain from the evidence that each plaintiff was induced by the defendant's promise to buy and build, being assured that the entire neighborhood would be restricted to residential purposes. But this is where I found it kind of weird. It said the trial judge found that the agreement restricting Lot 5 rested wholly in parole. It agreed in oral terms and was unenforceable. So that's where the plaintiff appealed. Did I get that fact right? I thought that it was like a weird flip-flop. Where he said it was not enforceable because it was.
Oh, you mean the lower court?
Yeah.
Yeah, they flipped.
They said one thing and did another thing.
Okay, yeah, you're right.
Okay, so the issue then is whether the contract for the sale of lands or any of any interest and or concerning them must be in writing signed by the party to be charged. So rule can be found in 641. Inequitable as well as the legal interest in land must be evidenced by some sufficient instrument in writing or it is unenforceable. So we get into the plaintiff's arguments. He said that they fully performed, so non-performance from the defendant of an oral contract constitutes fraud. The court rejected the argument because the non-performance of an oral contract required in writing under statute of frauds does not constitute frauds. And secondly, he said that the acts of taking title, entering into occupation, making improvements on their own estates in reliance on the full agreement to satisfy the written requirements. So once again, the court disagreed. So that's therefore they dismissed the case because they said this was unenforceable.
Okay, let me just ask you just a couple quick questions. Okay, so is this a is this a covenant that runs with the land question, or is it an equitable servitude question case?
it's equitable stewardship.
Okay, good, because they want what?
They want to prevent them from doing this. Oh, they want an injunction.
Against what, she said?
They were trying to. They wanted the restrictions into within.
But what were they trying to stop? You have to kind of see, this is your first look at common scheme. In other words, just the
Oh.
fact that it's a common scheme
I
means
see.
that everybody has to know that they're gonna be bound by certain restrictions, whether it actually appears in their actual documentation or not. Notice that almost half of the, and there's 91 different ones, right, in this case, 91 different little subdivisions, right? And of those 91, almost, I think more than half lack this covenant that says that they will keep it residential. So, you know, have to and have, kind of weird, huh? Although, if you look at the entire scheme and you look at everything that's there, what are all the houses? What's everybody put on their plan? Houses, which are what? Residential. What does this cat want to do? Ah, you guys, this is a great case. It's genius, what?
They wanna do commercial?
Yeah, but what? Okay, we're in Detroit. This is 1925. What are people all of a sudden doing in bigger numbers than they ever had before? Drive. So here's your big, this is this case, okay? You got about, I think it's 91 subdivisions, right? Right? Here's, I guess here's Collinswood, or whatever it is. Collinswood Street. And all these places are residents, right? So they're all residential, and about half, I think it's what, 56, maybe? 56 of them have no restriction. But you can see what it is. Okay, this entrepreneurial fellow wants to do what? He wants to put a gas station right there. He's bought this lot near the bottom. And here's his big plan though. You ready for this? If you think about it, it's pretty smart. People are driving home, right? What are they gonna do? People are driving out. What are they gonna do? Fill up at his station. Woohoo! There's only one problem. Sounds good. Wow, gas station right near us, but there's only one problem. Damn, there's a gas station right near us. Do you want to have a gas station in the middle of your gated community? No.
Professor, isn't that the McLean case?
Oh, is it?
That's the other case.
Well, what case are you doing?
Strong.
You flipped too many pages forward.
Never mind.
I was
Okay,
getting really confused.
Okay, that was really good. Let's go on to Sprague versus Sanborn versus McLean, which is actually the case I really like. I really like that case. All right. In that case, you're right.
Well, just as a practical matter, I think you just did the review of that one, so perhaps
Let's go on,
just finish
shall we?
that one and
Sorry.
go forward.
I just got very excited by it. I just love that. That to me is just, it's kind of on one level it's genius and on the other it's really insidious. You know, it's like putting a gas station in the middle of residential. Okay, good job. Even if it wasn't a good job. Good job. Let's move on. Okay, Snow versus Van Dam. And that's not Claude, by the way. Pointed out to me one time.
Jean-Claude.
Jean-Claude.
Who consequently is like popping up into commercials now, which is like super bizarre to me.
That's
If it's not Bloodsport, I don't care. Right? Surgeon. It's got Ogre from Revenge of the Nerds.
true.
I know. I know. By the way, can I just ask if everybody in the room has seen Revenge of the Nerds?
Oh, classic.
I'm looking at you because you're the youngest person in the room, I think.
So classic.
I mean, I'm probably more offended than when you fell asleep in front of me during my seminar.
I have like a list of movies.
Assignments during Christmas. Okay. I'm not saying that you have to watch all of the movies, but the initial one is very good.
You have a lot of movies to
Just
watch.
saying. I can give you a list. Your movie education.
this case
Pitch
is good
perfect.
too.
Your vacation.
Vacation.
See, you got that one. Right. I will say this before my lovely husband comes back in, but he very much loves the Pitch Perfect movie. So every time they're on, I have to watch them.
Which one's pretty good.
I like them, but it's a little aggressive every time.
I like the cup thing.
Uh-huh.
It's cool.
All right, Snow versus Phantom.
Alright, I like this case too.
Don't all jump at once. Going once, going twice. Yours.
Okay,
A lot of really old cases, right?
yeah.
Mm-hmm.
Snow versus Van Dam. So between July 1907 and January 1923, almost all the lots were divided and sold to various individuals. I also tried drawing this one out, I'm not sure how well that was drawn out. Sold to various individuals, including the plaintiffs, with restrictions on the use. The restrictions in the deed state that only one dwelling house can be built on the lot, and the building may not cost more than $2,500. If the owner of the lot wishes to build an outhouse, the owner has to seek permission of the grantors. In the section that was low and marshy, in the neighborhood, it was sold in 1923 to Robert Clark. It was subject to the restriction which stated that only one dwelling house may be maintained on each of said parcels of land at any given time, which dwelling house shall cost not less than $2,500, unless plans and specifications for a dwelling house of less cost shall be approved in writing by the grantor of said parcels of land, and no outbuilding containing a privy shall be maintained on either of said parcels of land without the consent in writing of the grantor. So Clark conveyed a lot in the market area to defendant Van Dam, and it was subject to the restrictions insofar as many as the same may be now enforced and applicable. The phrase could not have created any new restrictions. It says that the defendant erected a large building to use as an ice cream store on the premises. And they also says for business common victualler.
You know what that means? I had to look that up myself.
I
It's
did,
called a
it said selling
victualler.
food or other provisions
Yes.
or someone licensed to sell alcohol.
Okay, and what do we call a victualler today? We don't use that word anymore, but it's a word that actually encompasses everything that you just said.
Vendor.
Close, it's even more common than that. It's another word for, no, really? Restaurant.
Oh, man.
But we just don't use this word anymore. But in 1923, they did. And I was looking it up and wow, that's cool. You know, they were actually, this was actually a place you could actually sit down and eat. How about that, man? Pretty cool.
Okay, so the plaintiff sued for an injunction claiming a violation of the restrictions. So my issue is, was the defendant's use of a lot for the ice cream business a violation of the deed restrictions of the community? What I have as my rule on page 647 is a restriction to be attached to land by way of benefit must not only tend to benefit that land itself, but also must be intended to be pertinent to that land. If not intended to benefit an ascertainable dominant estate, the restriction will not burden the supposed serving estate, but will be a mere personal contract on both sides. There was heavy analysis on this one. So the court said that in the absence of an express statement and intention that a restriction upon one shall be pertinent to a neighboring lot can sometimes be inferred from the relation of the lots to each other. In many cases, there is an establishing of a scheme for restrictions upon lots in order to obtain substantial uniformity in building and use. The existence of this scheme has often been relied upon to show the intent that the restrictions be pertinent to every other lot in the tract included in the scheme. They talked about the English law and the Massachusetts law. Said the English law established that the area covered by the scheme and the restrictions imposed within that area must be pertinent to the several purchasers when the sales begin. The purchasers must know from the time of the first sale the extent of property affected by a scheme The English law further stated that if a scheme exists, there is an implied right of property owners to enforce the restrictions of the scheme against all land within the extent of the scheme. We also had, the statute of fraud prevented the enforcement against the vendor. And only when the vendor binds his remaining land by writing can the reciprocity of restriction be between the vendor and the vendor be enforced. But they said, however, for Massachusetts, and Massachusetts law states that the oral or implied agreements by a grantor to similarly restrict all the grantor's property are not enforceable and violate the statute of frauds. They rely on the individual conveyances imposing similar restrictions, and the party seeking to enforce the scheme has the burden of proof of proving its existence. In this case, there is no evidence of a scheme, but there is a list of conveyances of different lots, ranging back from 1907 all the way through 1923. And it showed substantial uniform restrictions. It also showed that the subsequent deeds were relied on to showing a scheme existing at the time of the earlier conveyances of the parties or the creditors is entitled, and therefore they said that the evidence demonstrates the existence of a scheme.
Pretty good. That's actually pretty good. Okay,
So the injunction was granted.
okay, well, let me just just cover this real quick. That's good, that's fine. Okay, but here's what actually happened in this case, just so you know. Again, really smart stuff. That's why I like this case. We got some real smart Alex who are trying to just pull some fast ones. But this one's even better than that one, quite frankly. But oh, and by the way, vitualler, another word you don't hear anymore, is victuals, which is another word for, what do you think? Victuals. People used to call what as a sort of a common name for all of them. Food. Victuals, things you ate. Usually probably mostly for fruits and vegetables, I think, but it was pretty much for everything. So again, another word that's kind of gone, into the history books. Anyways, with that said, hey, I like ice cream, I like gas stations, and I like food. Deal with it. Anyways, with that said,
In every city, there's a Snappy Snack Shack. If you can tell me what movie that's from, I'll give you extra credit.
do not infringe.
80s.
No. I should know.
Who was that again? God.
They refer to a Snappy Snack Shack. Unless I got it wrong, but I don't think I did. Christian Slater. Winona Ryder.
Oh.
I should
Oh.
know.
I literally have it in my car right
It's
now.
the,
Shannon Doherty.
Oh, the breakfast? No, she.
No.
No, that's not the breakfast.
Feathers. Add it to the list.
Oh, yeah.
What was it?
It's a great movie.
It's a good movie.
Oh, you know what? They actually just redid the movie as a TV series that's terrible, but the movie is amazing. Enjoy it in all your free time.
Over Christmas.
Mm-hmm.
So just the short version is kind of interesting. I drew it upside down, by the way, in case any of you ever do map this out. It's actually north and south. But with that said, so here we have a situation where what happens is that we're coming into the 1920s, 30s, and one of the things that's getting what they're finding they can do, it's very interesting historically where we are today. But what it is builders are figuring out ways to fill in marshlands. And what they do is they finally find a way that they can bring in gravel and all this different stuff. And they can finally make it stable enough so that you can actually build homes on it. For many years you couldn't. And so all of a sudden in the 30s and the 40s and on, they're developing these technologies. And so if you ever wonder about that from time to time, why all of a sudden nobody really thought much about marshlands and all of a sudden they became an endangered species, that's actually why, is because builders figured out finally how to fill them in. And so they started building on them. For another day, but I could talk and give you a lecture for an hour about why we need wetlands and everything like that. Just silly things like clean air, clean water. Call me a radical if you wish. That's
Radical. Just kidding.
Indeed. But what happened in this case is, so you had all these residences up here, right? And then what you had here is actually the ocean. Kind of cool, huh? And so what happened was, this area used to be a marshland, but then they found out that they could fill it in and build on it. The problem is that this was residences. None of these new places that they were building said you had to, there was no common scheme here yet, because it was brand new, et cetera, et cetera, et cetera. And the deeds were weird and restrictions, and it's being built. So there's no really common scheme here. And so this fellow who, again, this wily victualler, decides that he wants to sell ice cream. This is genius, isn't it? I mean, between the ocean and homes, he's selling ice cream and ice cream products. My kind of guy, I have to tell you, that's pretty smart. Unfortunately, the residences were smarter. What did they do? They said, yeah, it's true that there's really, this doesn't really have the same, look that this has, but it should. And if you're building things here, you should expect, right? Just from this, I mean, all you're doing is moving closer to the ocean and building more structures, right? You should expect from this that this would be the same and that this should all be residences as well. The court said, who won? Homeowners, right? So the court says, yeah, So it's an interesting case because even though this place hasn't been, you have to understand, see if you see between the lines, this hasn't been fully developed yet. So he's trying to pull a fast one, saying it's a different area. I shouldn't have expected to have this. Perfect place for ice cream, ocean, the whole thing. Right? Judge says, smart, but he loses. So again, common scheme. So it will extend into these types of new constructions. That's what this case is about, I think, anyway. Pretty smart though, huh? You gotta say that's pretty smart.
It's a good business.
Really good.
I mean, the gas station, man, it's still 1920s and we're still moving people because they fall in kind of suit backs and disappear. So probably the gas station didn't seem so bad at the time. Anyway, all right, we good? All right. Let's see what else is about it. So this is for the doctrine of implied negative reciprocal uses. So again, they don't have to be actual, they can be implied as well. The next case is Shelley versus Kramer. Does everyone remember Shelley versus Kramer? Can anyone just tell me very quickly what the facts of that case is and why you think it should be in this part of the book, and I'll settle for that. We've already seen the case once. We get to see it again.
I'll do it.
Okay.
Has to do with restricted covenants.
Right.
Compliance.
Again, there's no, theoretically, honestly, there's no bigger Supreme Court case than this. I think I'm just in memory. Huge case. If you want to be a common law guy, you gotta know this case.
Sorry. So on February 16, 1911, 30 out of 39 owners of property in St. Louis, Missouri signed an agreement which provided in part that no part of the property shall be owned or occupied by any person not of the Caucasian race. So the intention of the restricted covenant was to restrict the use of property against tenants or owners by people of the Negro or Mongolian race. So the entire district described in the agreement included 57 parcels of land. The 30 owners who signed held title to 47 parcels of that land. 5 parcels of the land were owned by African Americans, one of which had been occupied by African American family since 1882. So they held possession of the property for nearly 30 years before the restrictive covenant was executed. So on August 11, 1945, the Shelleys, which was an African American family, received one of the parcels of land for valuable consideration. And then in 1945, Kramer brought suit in the circuit court against the Shelleys, hoping that the Shelleys would be restrained from taking possession of the property and taking title away from the Shelleys. So the trial court denied the request on the grounds that the restrictive covenant from 1911 had never become final and complete. It was the intention of the parties that the agreement was not to become effective until signed by all the property owners in the district and the signatures of all the owners hadn't been obtained, so they said it wasn't enforceable. The Supreme Court of Missouri reversed and directed the trial court to grant the relief which Kramer was seeking. That court held that the agreement effective and concluded that the enforcement of its provisions didn't violate any rights guaranteed to the petitioners by the U.S. Constitution. So the Shelleys had already occupied the piece of the property after getting the judgment from the trial court. So then they appealed to the Supreme Court of the United States, arguing that it violated their 14th Amendment right, and acts of Congress passed pursuant to that amendment. Specifically, they're arguing that they've been denied the equal protection of the laws, they've been deprived of property without due process, and have been denied privileges and immunities as citizens of the U.S. So the issue is the validity of the court's ability to enforce land sale agreements which contain a restrictive covenant that exclude persons of a designated race or color from the ownership or occupancy of real property. The rule is that the court is not able to enforce land sale agreements which contain restrictive covenants that exclude persons of certain races or colors from ownership or occupancy of real property. It's been consistent, has been the consistent ruling of the court that actions of the state to which the 14th Amendment references extends to actions in state courts and judicial officials. So the court says that equality in the enjoyment of property rights was regarded by the framers of that amendment as an essential precondition to the realization of other basic civil rights and liberties which the amendment was intended to guarantee. Therefore, they say that Section 1978 of the revised statutes, which was enacted by Congress while the 14th Amendment was also under consideration, states that all citizens of the U.S. shall have the same right in every state and territory as is enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold, and convey real and personal property. And then they go on to say that in this case of Buchanan versus Warley, the court stated that the 14th Amendment and the statutes enacted in furtherance of its purpose operate to qualify and entitle a colored man to acquire property without state legislation discriminating against him solely because of his color. But they state that the difference between this court and the case at bar is that the present case doesn't deal with an action of the state legislatures. The court states that the 14th Amendment only protects from actions against the state, and they conclude by saying that the restrictive agreement standing alone can't be regarded as a violation of the 14th Amendment, their 14th Amendment rights, because it's not a shield against discriminatory private conduct. The action of the state courts in imposing penalties or depriving parties of other substantive rights, the court says, has been long regarded to as a denial of due process that is guaranteed by the Fourth Amendment. And the action of the states which the 14th Amendment references includes the actions of state courts and state judicial officials. It's never been suggested that the state court, or that the state court action is immunized from this. So it's clear that without the action of the Supreme Court of Missouri, that Shelley would have been free to occupy the properties in question without restraint because the trial court ruled in Shelley's favor. So in this case, it's the ruling by the Supreme Court of Missouri that when the state action is to deny the rights subject to the protection of the 14th Amendment, it's the obligation of the Supreme Court of the United States to enforce the Constitution. So the court holds that in granting judicial enforcement of the restricted covenant, the states denied Shelley the equal protection of the laws of the 14th Amendment and due process. So whatever else the framers sought to achieve, it's clear that the matter of primary concern was the establishment of equality in the enjoyment of basic civil and political rights and the preservation of those rights from discriminatory action on the part of the states based on race and color, so they reverse it. Sorry, that was so long.
Oh, well, at least you picked the right case. I mean, you've gone, I mean, people have written volumes and volumes about that case. It's really, again, when you know, you'll see it in common law again, and then you'll see it it'll start to hit you in real life, if it hasn't already. But, it's just a remarkable case. If there's no Shelley versus Kramer, there's no 1960s civil rights revolution. It's just that simple. I mean, never 64, 65, up to 68 would never happen. All those years without a different, these civil rights acts would have never happened without Shelley versus Kramer. There's just no way. It's just not gonna happen. So it's a huge case. So is it fair to say that why they put this in this part of the book, though, would be that if you even have a discriminatory common scheme, that it's not enforceable in a court of law, therefore, even if it's a private contract, it's still invalid. Okay, good, we're done. That's why it's here. Okay, so you can't have a common scheme based on discrimination. That's the short version. Okay, yeah, good job. Excellent. All right, McMillan versus Iserman. Okay.
Okay, so, the defendant Iserman, what I got out of this was he bought some, land on in a residential area. And he, knew about there was a restriction on the deed about negative easements that was back in 1958, which he was ready to abide by and go by. So he bought this land, but what he did was he made it into a mental handicap facility. Well, after this is the first time that the court came across where they amended the deed, but the restrictions were even more than what the original deed was, more than the original. So they were bringing up, that this was violating the 14th Amendment and things like that, and that. So the court looked into all of this. So they did bring up the issue of state public policy on this. And really what was happening is they wanted this to stay as a residential area and not as a mental handicap facility for this. And that they were, that the amendments were invalid, and what turned out was, so if the issue I had was whether the amended deed restrictions prohibited the use of subdivision property for a state licensed group residential facility is valid and binding upon the defendants. So, and really the amended deed restrictions was more restrictive than the original deed restriction. It did bring up the legislative support of that, say that they talked about zoning in order to implement the policy of the state that persons in need of community residential care shall not be excluded by zoning from benefits in normal residential surroundings. So, in light of all this, they were talking about that based on, the court said that amended deed restrictions here specifically prohibited state licensed residential facilities for mentally handicapped and is against the public interest and thus unenforceable on public policy grounds. They weren't even going to address the constitutional argument that was raised by the party about the 14th Amendment. So they, so they pretty much affirmed it of what the trial court had stated. And I didn't go back. So the trial court originally said that the defendant's motion for summary judgment basis that the amendment deed restrictions discriminates against mental impairment persons and thereby violates the 14th Amendment. So the plaintiff, that's how the whole thing started. The plaintiffs ended up appealing on this. So.
Pretty good. Okay, one question. Seems to be the question of the day. So why is this case different and why is it in your book? What distinction from the other cases are they trying to show you?
Well, I was getting state public policy and also the fact that
Well, but what is it? That's true, there is a big public policy part. in this case. I
And,
would notice that.
and that, I think the whole issue was that the restrictions were more than what the original
Oh,
deed
that's so
was.
very close. Very good. So what's this case about though? I mean, put it into the words of the, you're right, but put it into the words of this case. What is this case about?
I don't know, I had here retroactive of the original deed. It had residential property,
Yeah.
so they didn't want the mental facility on the residential, they were trying to keep it as a residential community and not bring in a facility, a state licensed facility. So that's for that.
I mean, you've actually said it. I'm just looking for different words that they
Different
use,
words,
that's all.
okay.
But you don't have to worry about that. That I don't care about as much. I can always teach you words. I can't teach you theory, right? You teach yourselves theory. I just shake my head or go up and down. It's up to you whether you get the theory or not. I do my best, and you got the theory. Here's a situation though where an owner buys and all the restrictions say fabulous. The problem is in this rules or the CCNRs or whatever you want to call them, it says that the rules can be amended anytime they want to. So he buys under the impression that he can put up this mental health facility because there's no restriction. They find out about it, and in the middle of him, he's already bought the land and he's already started building, they change it on him. Can they do that? Yes or no?
Yes.
Mm-hmm.
You say yes? What does this case say?
Well, and then he was saying that if he abides by the new amended rule, he's breaching the first.
Well, he can't, he can't do it anymore because they've changed the rules. But can the board, or whatever you want to call them, because it's not just this type of case, can they change the rules on you in the middle? Yes or no? Let's see. 656. Let's see. Second full paragraph. Let's go to. Let's see. Second full paragraph. We thus hold that an amended deed restriction does not apply to the lot owner who has prior to the amendment submitted himself or herself to a certain land use, which the amendment seeks to prohibit, providing that the owner justifiably relied on the existing restrictions and had no notice that it was even a proposal, which in this case was true. And two, the lot owner will be prejudiced if the amendment is enforced as to his or her. So again, a lot of this is just contract law. So this is a case where it's funny because a lot of times they can, associations or whatever else homeowners they change their CCNRs all the time. They change their CRCs all the time. And if you look at any of them, they all say we can change these. So I think it is fair to say you can change them if it's in there, except when you can't.
They justifiably rely on.
And so what's that? What's that word I'm looking for? It's just contract law.
Detrimental reliance.
Yeah, and what's the big word? I mean, they all come out of this word, all detrimental reliance also. Estoppel. So what is this case? It's an, is it more like really a real property case or a contract case? Well, contracts, it just so happens it's about real property, but even in real property, what works? Estoppel. Mhm. So that's what I was trying to get to. And the word I was trying to get from you was about amendments to pre-existing ones. That was the word I was looking for.
Oh.
But you definitely have the right theory. Everyone had the right theory. But that's what this case stands for, okay? And actually, it's funny because one of the very last cases I ever had was about this. It's really interesting because, you can, sometimes homeowners enjoy certain rights for like 10, 20, 30 years. And then all of a sudden, for good reasons, bad reasons, or indifferent reasons, the board changes and takes those rights away. Usually they'll avoid that by grandfathering in the persons that are already there, that they can just avoid it, you know? And say, yeah, you grandfathered in, but everyone else forget it. And this-
Until you sell it.
and if you sell it, you can't sell it.
We
without
start getting
rights.
into that next
Yeah.
semester.
And that's where you really draw the line. But they tried to do it, and but the funny part is, you know, and I said I have an easier way to do this though, much easier way. I said just put 2 people on the board. Well, I'll be darned, they did it, and they turned it the other way around. So, anyways, but it was an interesting case because we were arguing back and forth about whether we weren't arguing about whether they could change the rules or not. They could. It said so at any time and place. But the question was, had my clients, had they vested an interest, had they vested a right, that would be basically an estoppel argument. Never got to go to trial, so I don't know, because like I said, we just sort of walked away and said, you know what, we're just going to take over the board. They did. That kind of guys. Very cool stuff. Anyway. But okay. And then they thanked me profusely, and I said, I didn't do anything. You guys did all the work. I just almost with a joke said, get people on the board, and I'll be down. All things. All right, Jocelyn versus Pine River Development Corp.
I'll take that one.
Ooh, another beach area.
Nice. Okay. So facts is that defendant corporation purchased lot 26 and a large tract with no frontage from the 48 shore lots. So the corporation subdivided the large tract into 161 lots and sold 147 of them to various buyers, some of whom formed the defendant Pine River Association. The corporation conveyed lot 26 to the association so that its members could have access to water and could use the area for swimming, docking the boats, and for other recreational purposes. In fact, the defendants did actually that to lot 26. They cleared the land for that same purpose. Lot 26, the deed contained 4 restrictions limiting the number of cottages to be built on the lots. It's prohibiting mobile homes, requiring permanent buildings, finished exteriors, modern plumbing facilities, and imposing setback requirements. So this is where the parties disagreed on the meaning or effect of those covenants. Defendant specifically said that they argued that the proper rule of law to be applied in this case is that restrictive covenants are strictly construed to permit the free use of land, that all doubts must be resolved in favor of free use, and that no restrictions may be implied from those expressly stated. Trial court judge in favor of the plaintiff by granting a permanent injunction and joining the defendants, their successors, and all persons acting under their authority from using lot 26 as a common voting or each area or common ingress or egress to and from each, and so defendant appeal. Our issue presents that whether restrictions on dwellings or residences limit the use of the land itself apart from any building. The rule is rather lengthy on page 663. It said provides in determining whether building restrictions constitute such restrictions on the land itself. Courts often consider the location and character of the entire tract of land, the purpose of the limitation, whether it was imposed for the sole benefit of the grantor or for the grantee of subsequent purchases as well, and whether the restriction is pursuant to a general building plan for the development of the property. So the court went straight to it and said that the modern viewpoint is that the former policy of strictly construing restrictive covenants is no longer operative. And he said there's a greater weight given to the intent of the parties and will not defeat the purpose for which a covenant was established. He said that all these surrounding circumstances existing at the time of the creation of the covenants are taken into account in determining the intent of the parties. So in the given case, the restrictive covenants imposed on lot 26, although explicitly referring only to buildings, are obviously part of the general plan to prevent use of property in restricted part subdivision for any purpose other than residential. And so they agreed with the lower court and they affirmed the injunction. But I guess the main thing is intent.
Yeah, I mean, it's funny you should say that because I'm looking at my book right now, and again, we're in 1970s, so I've got intent highlighted like a bunch of times. Again, we're in that era where the courts are no longer looking at strict constructions, which is weird because one of the things, this case has always been somewhat, it's not a terribly difficult case when you look at it, but in 76, it was meant a little more than it would now. You're looking at an area where they even start the analysis by saying that, equitable covenants and restrictions and things of that nature will be strictly construed. Well, if you did that, you wouldn't come to this conclusion. But as the justices get into this, they start going, but there's this intent thing. And then they start to look around and they start to go, well, you look around and you say to yourself, water, ponds, what the hell do you think they were gonna do here? We can take that in consideration too? Yes? Yes, okay, we're done. So, that's what this case says. We think it's kind of neat there. You should have known that. Okay. Okay, if you read it differently, so be it. But that to me is how this case reads. Such a nice place. You can't change that. Okay. I'm so glad that restricted covenants are strictly construed, Your Honor. Bye-bye. Oh, yeah. But guess what? That's the way it is now. And guess what? Now you can use that word. Public policy. Okay, we want the free alienation of land.
It was just ill-timed.
It was ill-timed.
Uh-huh.
You did.
It's okay.
So, I like this case a lot too. Review versus Cheyenne Homes, Inc. Okay.
Hey,
And this is that.
How'd
This
you
is
say
kind
it's
of where we,
pronounced?
what?
How'd you say it?
Rue.
It's Rue
Oh, okay.
and Rue versus Cheyenne.
Rue. But then that's what I heard, and I was like, is it
The H is silent.
Rue?
Or Rue.
So Cheyenne Homes was the original defendant. Oh no, this is the defense, sorry. And they got an injunction against Rue. Rue was attempting to move a Spanish-style house into a neighborhood. The owner of the land placed a declaration of protective covenant on the entire area and recited it in the document and said, for the purpose of protecting the present and future values of the properties in the subdivision. Rue did not violate any of the few specific restrictions in the covenant, but there was also paragraph C2, which stated, no building shall be erected, placed, or altered on any lot until the construction plans and specifications and a plan showing the location of the structure shall have been approved by the Architectural Control Committee. So Cheyenne Homes was successful in obtaining the injunction at the lower court levels, and Rue appeals. So my issue is, does Rue's failure to submit their plans to the Architectural Committee enjoin him from placing the house on the lot? My rule I have on top of 666. So long as the intention of the covenant is clear, covenants such as the one before us have been upheld against the contention that they lack specific restrictions, providing a framework within the Architectural Committee must act, which the Architectural Committee must act. So, of course, Rue argued that the paragraph was not enforceable because there wasn't any specific standard contained to guide the committee in determining the approval or disapproval of the plan. However, the court said that submitting plans to an architectural committee is an accepted method by which guarantees of value and general plan of construction can be accomplished and maintained. Furthermore, the court said that if there isn't explicit criteria for approval, a covenant can still be valid if the purpose is clear. Here it is explicit in the covenant that the purpose of the restrictions is to preserve property values. The court continues by saying that even though the requirement of submittal to an architectural committee is valid, a purchaser is still entitled to protection and due process of law, and the refusal must be reasonable and made in good faith and must not be arbitrary or capricious. The facts show that 2 out of 3 committee members testified that they would have disapproved of the plan if it was submitted because the houses are primarily made up of brick construction with asphalt shingles and were no older than 2 years. Whereas Rue's home was over 30 years old and had stucco exterior with red tile. Therefore, the committee's decision was reasonable and it was made in good faith. So the judgment was affirmed.
That's good. Good job. Good reading of the facts. Okay, so just very, very quickly, just get another little pointer today too. On 665, what you see here, if you start reading, and again, this is 1969, so you don't see this very much anymore. Judges don't tend to do this, but I give you a little heads up if you ever want to know where the cases are going. Notice that when you get down to about a little bit past halfway of the page, what you're seeing now is they're kind of laying out the case, and here's, they're telling you about what the law says, and then they're giving you what they're talking about. Saying plaintiff and C2, no building shall be erected, you see that part where they give the law? The next line says plaintiff's in error. Now you know who lost.
Oh, yeah.
Yeah, they don't do that very much anymore, mostly because I don't know. I think they like to keep you in suspense at the end. But they used to actually say that a lot, so you would know who won up front. So you wouldn't have to read 50, 60, 70 pages to find out who actually won. You now know the plaintiff's lost. And they would usually do that very near the front. They don't do that anymore. And the funny part about it is, I only mention that because if you remember a couple of years ago in the Obamacare case, the actual decision, this case called Sebelius, is actually about 120 or 30 pages long. And the thing is they were looking at different aspects of the Constitution. Well, if you read the first 60 pages, it was brought on 3 counts. Obama actually lost. The president actually lost the first count. And reporters, because they want to always be first, they ran out and they wrote that the Supreme Court had overruled Obamacare. And I was actually watching TV. I saw this. And I was sitting there going, I can't believe this. This is unbelievable. Blah, 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 blah. And all of a sudden, 5 minutes later, someone broke in and said, wait a minute. On the second count that they had brought, they had sustained the law. And so that wasn't true at all. So it would have been nice if they had said up front, by the way, the law's going to be here. Okay. So, and it was just kind of just thought as a smart thing back then to just say up front, you lost. But they don't do that anymore. Kind of bizarre, huh? It's one of those things they just don't do. But anyway, so if you're ever reading these cases, particularly from about 18th and early 1900s up to about really 1930s or 40s, they usually will tell you. It'll usually say something like plaintiffs in error. It's usually somewhere in the case, or defendants in error, or appellants in error. You see all those different ones back then. They don't do it anymore. Anyway, so, but just heads up, you do see that, you know who lost. Okay, it's not gonna, oh, by the way, we changed our mind. That's who lost. And that's the way they used to do it. Okay, so that was the end of the game for that. Anyways, I think for better or for worse, it's just a pretty straightforward case. With that said, here you have a bunch of houses that all look the same, and they're trying to bring the Spanish style. By the way, it also, if you look at the facts between the facts, this house was huge compared to the other ones, by the way. It wasn't really just the color. It was like, this thing was huge. And it was like, whoa, and it really stood out. And, are they allowed, even though there was no actual written description, it's a weird technical case. They're saying there was really no way that they could make this decision because there was no real written down rules of how they made decisions on such things. And the justices are, again, saying what when it comes to such things? Can you take the entirety of all this into consideration? And so again, it's another one of those cases is like, well, what do you think they thought was coming into that spot? And that's also a catchphrase for what? Think about it. That's a catchphrase for what? Intent. What do you think you intend to the homeowners there already were thinking you were going to bring in here? A medieval temple? Why don't you just put, a big rocket launcher? How does that sound? No, why not?
Would make it interesting.
It would. All right. I do believe this is last but not least, right? Cowling versus Colligan. Okay. Send us out the door on a high note. Yay!
So this is a Supreme Court of Texas 1958, Callan versus Colligan. Callan was representative of a class action lawsuit of a group of neighbors who were upset with this gentleman named Colligan who wanted to build a business Because his argument was basically, hey, there are some churches around here, I think I should be able to do a business. And, he argued the neighborhood had changed, which is what we talked about earlier. Since the original restrictions were applied, the law was adjacent, it was adjacent to other businesses, meaning the churches. However, I think applying the rules that we learned today would be that it didn't change enough. And it didn't affect, and he was basically the only one affected by this benefit, and the other residents would all be burdened by it. So the lower court ruled that the restrictions laid by the instrument of record are valid and enforceable, but that it's no longer just and equitable to enforce the restricted covenants against the one tract and prevent the use of it for business and commercial purposes. So the issue that I had is if there is a change in the condition of the neighborhood, is the current restriction unjust? No, the court determined that the neighboring lot owners did not waive or abandon the restrictions allowing on residential use, and that any change in use in the surrounding area was insignificant, primarily because only one person, him, was going to benefit, and what was not considered was the harm that would have been done to the other homeowners.
Okay, that's pretty good. That's fine. I mean, not a terribly difficult case. There is one last thing though, just about this case again, kind of an ongoing theme. But notice again how these are mostly contract cases. Now, why do I say that in this case? What's the issue they're discussing? That it's just straightforward contract law. I mean, he wants to bring a business because he's claiming that the neighborhood is changing. Is that so?
No, it's changing a little bit, not enough.
Well, but he's saying
It
that
is.
it's changing. So I should be able to keep changing it, right? Is that true? Okay, that's what he's saying. And he actually points to some examples, one in particular that I'm
Oh,
thinking of.
the road is going through.
Well, another one too, which he says, what, acts as a, in other words, I won't be the first person that you're making an exception for. That's true, he's right, because they put in a what?
Church.
You put it in a church, okay, you can see the thing over here, or at least they talk about that. And so he's claiming that by already allowing differentials, it acts as a waiver.
Right.
And that's what this case is, it's a waiver case, which again is basic contract law. But what did the court say? Interesting, but in the context of real property, waivers, they just, I mean, they're interesting, but what's the standard if you want to actually bring in something that's outside? It's not waivers. It's, you already said it.
You just know I said it.
Twice, actually. Whether you waive for any particular person is not the issue. They said it's interesting, it's certainly factually relevant, but you can only do this if, what's the only exception to the,
Oh, the common scheme plan thing?
Yeah,
Is
what's the only
if it's,
exception?
The changes.
the
If it
changing
changes
of the
significantly.
neighborhood? And this doesn't
Pervasive.
constitute a change of the neighborhood, so it is a waiver.
Right, so there's not change conditions in this
Right.
case.
Yeah.
They're just mere pockets.
Yep.
Right?
This is the pocket case, right? This is the little areas here and there. Waiver, interesting theory, but they say that's not the standard. It's the changed neighborhood. Yes?
Yes.
Okay.
So that's the end of all the information you have to know for the first semester.
Okay.
You're supposed to smile when I say that. Yay, right? Okay.
And
You're
next
too
week's
tired to
review,
smile.
so.
I don't feel like smiling ever again. I had the never again moment with one of my kids. He got upset about something. He said, "Never going outside ever again." All right.
I remind me of my brothers, he used to say, he would get water on his shirt. And he'd be like, this is the worst day of my life.
It's so dramatic.
So what happened with the, what did he?
He got embarrassed about something and didn't want to go back outside because he got scolded for misbehaving, and he came inside and I came inside to see if he was okay. And I just said, what's going on, buddy? And he told me, and I said, well, why don't we just sit here and relax for a little bit? You wanna help me make lunch? Yes. Okay. You wanna take off your coat and your beanie? Yes. Okay. How about we just cuddle for a few minutes first? Okay. So then he was like,
Oh,
just, yeah. Oh my God, how dramatic. I'm never gonna fight again.
That's to hurt you.
Huh?
That's to hurt you. He's like, see, it was fight, I was fighting.
Well, I was the one that scolded him.
Oh, really?
So I just got to be discomforted.
Oh, cool.
Funny, my friend was talking about something similar, but not exactly the same. He looked at me and goes, remember when we thought the most important day of our life was our high school prom?
Oh my God.
Oh.
I went, yeah, that was the 80s.
What did you remember what you wore? What? Remember what you wore?
Powder blue.
Powder blue. My friend Steven did though. And then another one of my friends, he wore kind of a pinkish one. I just wore dark blue. He wore a pinkish one, and it was really funny because everyone called him strawberry the whole night. All right, guys, keep your work up. And this is not an easy class. That's what we're doing. Good on you for looking at work.
Oh, I was like, I've never seen this. I feel like, oh my God, I feel like we're gonna get asked this.
I mean, for me, it's like, if I don't look up word, I can't get out of it. Even with GPS. So it's just easy, you know, just come up with stuff. I don't know.